Head to Knoxville, don't be late. Baker's Live, it's gonna be great. June 5th and 6th, mark your date at Dollywood, we'll celebrate. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. Rides, fun, and meet and greet. Baker and pals, the crew's so sweet. Get ready for laughs, cheers, and thrills. Knoxville's the place, it's giving chills. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. June 5th and 6th, don't miss the fun. Meet Baker and friends, it's second to none. Baker and friends, it's second to
Good morning, good evening, good afternoon. Wherever you are, whoever you are, what if any you might be. There has been a small dump of motions. If you look at the top of your screen, I have downloaded all of them so far. And now the mass court system is down. 30 motions so far, 6 more that Marissa and Jemima didn't catch before it went down. My poor computer is struggling a little bit today. Because 30 new motions is a little bit... Good evening, genitals. It's, even though I have quite a few RAMs in my computer, it's it's a lot. Kurt already covered them. Well, what am I doing then? See you later. Let's just say I can hear my blower moving a little bit faster today. Thank you so much, Anime. Well, it's my old glasses, but there will be a lot of reading, so I might need them. I'm not going to read every single word of every single motion. Some of them are just standard. We've seen it before. It's filed in every case. It's just to make sure it's on the record. But there's some of them that I find quite interesting, and we'll deeper dive into those. Yeah, I have a bigger dinosaur today. Yeah, these are my old glasses. So, but there's not as much strength in these as there is in my everyday glasses. So maybe they can help me read. No, these are actually Come on now. They are non-violence glasses. Apparently inspired by John Lennon or some crap. But if I want to go to bed today, we got to get started. 557 is the Commonwealth motion for a protective order. Pursuant to Rule 14, for this honorable court to establish a protective order restricting the public dissemination of all communications to be provided to the defendant on March 10th, 2025, detailed in the Commonwealth's Notice of Discovery. This order is necessary to effectuate the well-established privacy and safety interests of the witness and the victim's family. Furthermore, certain materials being provided as discovery in this case may be evidence in an unrelated pending criminal case. I found that a little interesting. The issuance of a protective order is the inherent authority of the issuing court, and protective order serve to shield litigants and third parties from unwanted disclosures. So they turned over some discovery on March 10th, and that should be under a protective order. And kill this and then go to this. Probably more of the same BS as always. The next one, 558. Defendant's motion in limine to present demonstrative exhibits based on Christina Hanley's testimony. This motion is just that they want to have demonstratives, or chalks as they are called in this room. Christina Henley is the expert. Well, what the hell is she the expert of? She's a forensic scientist of the Massachusetts State Police. Yeah, let's read all of this because this is interesting. First, as the factual background, and then we get to, on January 29th, Mr. O'Keefe is captured on video surveillance footage leaving Waterfall Bar and Grill with a cocktail glass from the bar in his hand. The Commonwealth claims that this glass remained in O'Keefe's possession at the time he arrived at Fairview 34. And it looks like something is missing. And was broken in the early morning of January 29th outside the Alberts residence after being struck by the taillight of Miss Reed's vehicle. Over the course of several searches, law enforcement recovered numerous pieces of glass from the yard outside of Fairview 34 and the rear bumper of Miss Reed's vehicle. The source of the glass recovered from the bumper of Miss Reed's vehicle and the lawn is material and relevant to this case. At the first trial, Christina Hanley, a forensic scientist at the Massachusetts State Police Crime Lab, testified for the Commonwealth about pieces of glass recovered from the crime scene and from the bumper of Miss Reed's vehicle. This testimony lasted more than an hour and spanned 37 pages of the trial transcript. Throughout her extensive testimony, Ms. Hanley discussed 16 distinct pieces of glass recovered from 34 Fairview Road and the bumper of Miss Reed's vehicle. These 16 pieces of glass originated from 4 separate sources. Some pieces of glass came from the same source, meaning that they were original, a part of the same object. Ms. Hanley's testimony is very intricate and difficult to follow without some sort of visual aid. During trial, Ms. Hanley herself frequently needed to refer to her notes and requested that counsel repeated questions to keep the various pieces of evidence she was discussing clear. To remedy this problem, the defense proposes the use of a demonstrative aid consisting of one chart spanning one page containing representations of all recovered pieces of glass and graphics depicted which piece came from which source of glass. The proposed chalk tracks directly with Ms. Hanley's testimony and report. The chalk starts by identifying 4 basic categories based on where the pieces were recovered from and who they were brought in by. Each group of pieces is called an item. These items are item 3.2, the base of the cup recovered from the scene; item 3.3, 5 pieces of glass taken from the bumper of Miss Reed's car, viewed by the laboratory as one item; item 7 to 12, oh, that's what it means, 9 pieces of glass taken from the scene by Trooper Bukaki, viewed by the laboratory as one item; and item 7 to 14, a single piece of glass taken from the scene by Trooper Proctor. Each smaller piece of glass within item 3.3 and 7.12 have an additional lettered label referencing the individual pieces itself within the broader item. Item 3.3 contains the sublabels A, B, C, D, and E, each letter representing an individual piece of glass. These sublabels are the same as those assigned by Ms. Henley in her testimony and in her lab report. Similarly, the 9 pieces of glass in item 7.12 are labeled A, B, C, D, E, F, then I, K, L, skipping letters G and H as was done in Ms. Henley's testimony and in her report. Funny she's skipping 2 letters. That could indicate there was 2 other. Well, don't speculate. For each individual piece of glass, the charts include a graphic next to the corresponding label based on which other piece of glass that piece matched. The graphics in the columns next to each label correspond directly with Ms. Henley's testimony, particularly the testimony on page 75 and 76, 90 and 92 of June 5, 2024 trial transcript. Each sublabel will have a graphic next to it indicating which other piece of glass it matches. Through these graphics, the chalk summarized Ms. Henley's conclusion into a simpler chart, which Ms. Henley confirmed was an accurate representation of her testimony. To assist the jury in visualizing Ms. Henley's granular and essential testimony, the defense proposes the attached demonstrative exhibit or chalk to aid the jury, which is attached herethrough as Exhibit A. A demonstrative exhibit is something presented to the jury to help them better follow and understand the evidence, but is not evidence in itself. Demonstrative exhibits can take many forms, including live demonstration charts or even literal chalk figures on a blackboard. And there's a lot of case law. Demonstratives are particularly useful where a party presents complicated testimony that may be difficult for a jury to understand or visualize. Allowing a use of 34-page bar chart as chalk to depict hours defendant billed to medicate for a particular period. These sorts of aids are appropriate where they are relevant, they are not more prejudicial than probative, and they are sufficiently resemble the actual events so as to be fair and informative, and they are a fair representation of the facts and the chalks aim to clarify. Finally, the court has broad discretion in determining whether to admit a demonstrative aid. The proposed chalk is highly relevant. Ms. Henley's testimony is clearly relevant. Whether any of the glass on the bumper matches the cocktail glass at the scene or is from some different unidentified source, and goes directly to whether the evidence in this case supports that Ms. Reed struck John O'Keefe or the cocktail glass in question. The relationship between the other pieces of glass are critical to understand the scene. Therefore, the chalk, which summarizes Ms. Henley's testimony about the glass, is also highly relevant, especially given that the chalk provides much needed clarity to an otherwise complicated issue. Without a chalk, the jury would need to be able to either accurately record or memorize the source of each piece of glass and each piece's relationship to all of the other pieces in order to make sense of Ms. Henley's testimony. The complexity of this testimony is underscored by Ms. Henley's frequent reference to her notes and request for counsel to repeat questions, particularly questions about the relationship between these pieces of glass. Of course, referencing notes and requesting the repetition of questions is permissible and even preferable to ensure that testimony is accurate. However, if a lab expert has trouble keeping track of the labels of evidence that she analyzed herself, surely the jury would have even more trouble making sense of this critical evidence, making the chalk not only relevant but essential. And this is the thing we have talked about many a time. More visual aids in this case. We need them because it's such a highly it's such a hard case to follow along with all of these. Who found what, where, when, and why? Notice this is the defense who wants to bring this in. Because this evidence is where Lally said, well, the glass embedded in the bumper was from the cocktail glass, even though she said, no, it's not. So I should think that this would be appropriate, but again, it's Bev's court. I'm not sure that she's going to allow it, but she should. Let's just say that. But again, it's Bev, bias Bev. The chalk would not prejudice the Commonwealth. Any prejudice that may be argued to stem from the chalk is far outweighed by its probative value. The chalk does not prejudice the Commonwealth in any way. Rather, the proposed chalk would be highly probative in relation to Miss Hanley's testimony, which would otherwise require jurors to memorize and differentiate the title and source of various pieces of glass with labels that closely resemble one another. It is merely a depiction of which glass pieces match others and a visual representation of Miss Hanley's live testimony. Given that the chalk corresponds so closely with Miss Hanley's testimony, a witness for the Commonwealth, it is difficult to see how the chalk could be remotely prejudicial. Even if the court finds that there is some prejudicial tendency in the proposed chalk, it is far outweighed by the probative value. The Supreme Judicial Court of Massachusetts has been liberal in allowing demonstratives and chalks, even where there is a potential for extreme prejudice. In Commonwealth v. McGee, where the defendant was accused of unaliving his partner in front of their 6-year-old child, the Supreme Judicial Court of Massachusetts upheld the allowance of a physical demonstration by that child, then 10 years old, of the position in which he saw his mother on the couch when she was unalived. In support of this decision, the court highlighted that testimony about the decedent's position on couch at the time of her unaliving was crucial to determine whether the premeditation element of murder in the red rum in the first degree was met. Given that a live demonstration by a child of the position his mother was in when she was unalived was permitted as more probative than prejudicial, the proposed chalk, which simply depict Miss Hanley's testimony, is certainly more probative than prejudicial, if prejudicial at all. The proposed chalk directly mirrors Miss Hanley's testimony fairly and accurately. As described in details above, as seen in the chalk itself, the chalk is merely a summary of Miss Hanley's testimony. The 4 categories displayed in the chalk, the labels used in the chalk, and the connection between each piece of glass are all drawn directly from Miss Hanley's testimony. In fact, during the first trial, Miss Hanley was shown this exact chalk, which she confirmed on the record was an accurate reflection of her testimony. Conclusion. Without the chalk, Miss Hanley's testimony will be exceptionally difficult for the jury to follow, which would seriously detract from the important evidence Miss Hanley will present. Given the great relevance of the content of this chalk, its lack of prejudicial tendency, and the tight relationship between the chalk and Miss Hanley's testimony, the proposed chalk should be permitted. For the above reason, Ms. Reed respectfully requests that this honorable court allow the attached chalk to be presented to the jury. I agree, because it's very, very, very hard to follow, and I think James Bond figured it out. It's because it's a feature, not a bug, that you can't follow along. That's I could swing for a banana milkshake. Chloe, if you come on and read the rest, I'll drive and get us a milkshake. I don't know. Maybe it wasn't for me. But 2 down. Oh, maybe we can better see it here. Defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. Now comes defendant, and respectfully moves that honorable court in limine to exclude any reference to the irrelevant, inadmissible, and prejudicial events that purportedly transpired in Aruba on December 31st. Yes, sir. As grounds for this motion, the defendant states that the proffered evidence is not relevant to any material issue in the case, should never have been allowed in the first time. Should the court find that the evidence is relevant, any potential probative value of the proffered evidence is outweighed by its substantial risk of unfair prejudice to Ms. Reed. 100%. And factual background, it's the same every time. The defense suspect that the Commonwealth will again seek to admit testimony regarding a completely irrelevant verbal argument between Ms. Reed and a woman named Marietta Sullivan, which occurred in Aruba on December 31st for the sole purpose of trying to assassinate Ms. Reed's character in the eyes of the jury. At Ms. Reed's first trial, every single witness unequivocally testified that there was no history of violence whatsoever in Ms. Reed and Mr. O'Keefe's relationship, and that the two of them were in good spirits on the night of January 28th. Despite this, the Commonwealth repeatedly elicited inadmissible testimony regarding a verbal incident that occurred in Aruba 1 month prior between Ms. Reed and a third party, which had no logical relationship to the crime charged. Yes. The Commonwealth has no reliable evidence to suggest that the Aruba incident had anything whatsoever to do with John O'Keefe's unaliving a full month later in January 29th, or that this remote and isolated incident was even a point of contention in Ms. Reed and Mr. O'Keefe's relationship after the trip. At the first trial, the Commonwealth called Laura and Marietta Sullivan to testify about a highly inflammatory incident in which Ms. Reed apparently got angry at another woman, not the decedent, because she purportedly believed that Mr. O'Keefe had kissed that woman. The Commonwealth intentionally admitted this prior bad act and character evidence for no reason other than to sully Ms. Reed's character in the hopes that the jury would indict her based on the fact that she was, in Marietta Sullivan's word, an asshole. I love that they took this part and put in here. At trial, Laura Sullivan admitted that she was not present during this verbal exchange between Marietta Sullivan and Ms. Reed, so her testimony about December 31st incident in Aruba is almost entirely comprised of inadmissibly hearsay. Despite the court limiting instruction about bad character and propensity evidence, the Commonwealth was permitted to elicit prejudicial testimony from Laura Sullivan that Mr. O'Keefe purportedly called Ms. Reed crazy. Ladies, close your ears. Fellas, have you ever called your girlfriend crazy? Maybe you've been out drinking and you really wanted to drink some more. And she started acting, you were a little drunk, and you said, yeah, the old ball and chain, she's crazy. Eddie, close him. I have to admit, I have called women crazy before. This weekend, I think I called both Jamie, Iris, and maybe even Panilla or Winesaw crazy. Mostly because they were crazy. This is absolutely BS. Of course I can. Or I'll call you crazy and you can use that against me in court. Well, I could sit and read every single word, but I have at least 28 tabs left. You are not going to look up Massachusetts. Well, there's no case law right here. You're not going to look up 22 RT at 33-1 to 37-10-25, which is trial court reports that we don't have access to. I don't care. As a woman, I call women crazy. Mm-hmm. Yeah. Zach needs a GoFundMe for Chapstick with all the kisses he's dishing out. He is a corner kisser. Crazy isn't a literal term. It has several meanings. It's also hearsay in the context, I would think. Yeah. And sadly, Bev showed her very annoying bias when she allowed it in, because it shouldn't have been allowed in. You could say, well, maybe Marietta could talk about it, but it didn't have any bearing on John O'Keefe. But Laura Sullivan had nothing to talk about. And that he had insinuated he was unhappy in their relationship. I love insinuations because you can insinuate a lot of things. Marietta Sullivan's trial testimony was also extremely prejudicial to Miss Reed. Her retelling of the verbal dispute with Miss Reed was not probative of any material fact or element in this case, and it culminated with Marietta telling the jury decidedly that Miss Reed sucks, which is a legal term that, of course, should be allowed in case. As set forth therein, the evidence must be included. The Aruba incident constitutes inadmissible prior bad acts and character evidence, and any potential relevance is outweighed by the risk of unfair prejudice to the defendant. Motions in limine concerning the introduction or exclusion of purportedly relevant evidence are properly made and considered before and during trial in advance of the evidence being offered. Commonwealth v. Spencer. The purpose of a motion in limine is to prevent irrelevant, inadmissible, or prejudicial matters from being admitted in evidence, and in granting such a motion, a judge has discretion similar to that of which she has when deciding whether to admit or exclude evidence. Commonwealth v. Hood, Commonwealth Tartino. It is a fundamental rule that the prosecution may not introduce evidence that a defendant previously has misbehaved, indicably or not, for the purpose of showing his bad character or propensity to commit a crime charge. Commonwealth v. Baker. That's why I can't go back to Massachusetts. Although this type of evidence is sometimes admissible for all other relevant purposes, such as to prove a common scheme, pattern of operation, absence of accident or mistake, identity, intent, or motive, these exceptions are not without limitation. Citing Commonwealth v. Tribbett and Commonwealth v. Helfand. Similarly, although evidence of a hostile relationship between a defendant and his spouse may be admitted as relevant to a defendant's motive to unalive the victim, such evidence should not be admitted if it relates to events which occurred at a time too remote from the unaliving. Commonwealth Gill, Commonwealth Abbott. Animosity between husband and wife 3 years before murder too distant to be probative of husband's motive. And Commonwealth v. Burke, evidence of defendant's husband's adulterous relationship which terminated 7 months before wife's passing, not probative of motive of red rum. Temporal remoteness is not an exercise in line drawing. Rather, a reviewing court focuses on the logical relationship between the prior bad act evidence and the crime charged. Commonwealth v. Pino, Commonwealth v. Fasella. Here there is no such logical relationship. In order for evidence of a prior hostile relationship to be relevant to the defendant's motive to unalive the victim, the evidence must actually establish a prior hostile and violent relationship between the victim and the defendant. Commonwealth v. Daling Huang. Prior acts evidence included police testimony about a domestic dispute requiring law enforcement response and witness testimony about multiple physical disputes between defendant and victim in order to show the nature of the relationship. Commonwealth v. Rentala. Another case we followed. Evidence include defendant's prior arrest for DV, multiple restraining orders, and pending divorce proceedings was omitted to show the nature of relationship. Commonwealth v. Almeida. Evidence of defendant's prior threat to stabulate victim to death was introduced to show the nature of the relationship. Commonwealth v. Oberle. Evidence including extreme physical violence, multiple emergency room trips, and threats to unalive the victim was admitted to demonstrate the nature of the relationship, as well as defendant's intent, motive, and absence of mistake. And Commonwealth v. Miller. Evidence including extreme physical violence and threats with a pew-pew was admitted to show nature of relationship and motive. This case law is not comparable to this incident, during which Ms. Rees briefly became angry with another woman, not the decedent, because she believed that Mr. O'Keefe had kissed that woman. There are zero physical violence here, no threats of violence, no police involvement necessary, and absolutely no history of violence in Ms. Reed's and Mr. O'Keefe's relationship. Moreover, even when this type of evidence might be relevant for some limited purpose, the evidence must be excluded if its probative value outweighed by the risk of an unfair prejudice to the defendant. See Ivet G. Commonwealth Oberle, Commonwealth Creighton. Section 404b2 permits the court to exclude evidence of a crime, wrong, or other acts that is offered for a proper purpose, i.e. to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident, if the risk of unfair prejudice simply outweighs the probative value of the evidence. This is a more exacting standard than the standard set forth in Section 403. Excluding relevant evidence for prejudice, confusing, waste of time, or other reason which permits the court to exclude relevant evidence if the danger of unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence substantially outweighs the probative value. Compare EVIT Code 403 with EVIT Code 404b92. That is because bad act and propensity evidence is inherently prejudicial, and the risk of improper use of enormous Commonwealth Creighton, Commonwealth Woodlam, were offered to establish motive of prosecution for first-degree red rum. Testimony regarding the changes in defendant once he began using drugs, including the statement that defendant had become a little more violent and was more prejudicial than probative. Stick around, folks. Maybe you can become an emoji. Thank you for 16 months. Yeah, you became an emoji last week. Well, we just started. This is the third motion out of 30. I'm never going to bed. Who wrote these motions? This is written by... This is really stupid moving down here. This is Alan Jackson. Or Miss Little. We were here. So Bev will allow them in. Yeah, I think that's the easy conclusion. Well, don't be afraid. Just close your eyes. There's also a really, really stupid... Well, we're going to get to those. Massachusetts courts had long held that where evidence of prior bad acts is relevant for purpose of such as intent or motive, it should be excluded if its probative value is outweighed by the risk of unfair prejudice to the defendant, even if not substantially outweighed by that risk. Commonwealth v. Voir, citing Commonwealth v. Creighton. Here, testimony by Marietta Sullivan that Miss Reed became angry with Marietta, not the decedent, on December 31st because she believed that Marietta had kissed her boyfriend John O'Keefe is simply not probative as to whether Miss Reed has an intent to red rum John O'Keefe on January 29th. This event was remote in time and was clearly not an issue between O'Keefe and Reed on the night in question, as evidenced by video surveillance footage from the Waterfall Bar and Grill on the night in question and the testimony of 8 witnesses, all of whom agreed that the couple appeared happy and in good spirits. Spirits. Why did I say it like that? Spirits. There's no logical relationship between Aruba and a crime charge. The Commonwealth's attempt to characterize this misunderstanding as some sort of turning point in Miss Reed and Mr. O'Keefe's relationship is off base and unsupported by the evidence. The sole purpose of the Commonwealth's attempt to admit this evidence is to sully Miss Reed's character by allowing Marietta Sullivan to testify that Miss Reed sucks. If we are to believe the Commonwealth's best evidence, i.e. that Miss Reed said, "Go fornicate yourself," to Marietta when she temporarily believed that she observed Marietta kissing her boyfriend on New Year's Eve in Aruba, that evidence is simply not probative of the motive to red rum Mr. O'Keefe, other than more than a month later, when the parties were, by all accounts, in good spirits. In order for there to be a logical relationship between the prior bad acts, evidence, and the crime charged as required by Commonwealth v. Pino, the jury would need to believe that Miss Reed reacted with a verbal "go fornicate yourself" when she believed that she had observed adulterous behavior on December 31st, but then subsequently flew into a murderous rage a month later when this event was remote in time and not the subject of any argument on the night in question. That type of reasoning defies logic. Miss Reed's short-lived anger was not even directed at Mr. O'Keefe, and her apologetic conduct after the incident demonstrated that she knew the kiss could have been a misunderstanding. The only reason for the admission of this evidence is to sully Miss Reed's character and prejudice the jury against her. Miss Reed asserts here that this evidence has no probative value regarding the crimes for which she has been indicted. However, even if the court finds that this evidence is relevant, any marginal relevance of Miss Reed's temporary belief that O'Keefe kissed another woman 1 month prior might have, in terms of evidence, a hostile relationship or intent to red rum is far outweighed by the prejudicial inflammatory effect it will have on the jury. The Commonwealth must be prohibited from calling witnesses to testify to inadmissible hearsay for the purpose of attempting to show a hostile relationship. Moreover, Massachusetts court had long held that the admission of hearsay statement for the purpose of showing a hostile relationship between the defendant and the victim is not permissible because it would entirely eviscerate the rule's important purpose of securing the correctness and completeness of testimony through cross-examination. Commonwealth v. Seabrooks. The Commonwealth's argument in prior proceeding to this testimony is admissible in order to show the defendant's state of mind is misguided. Again, the events in Aruba took place a month before John O'Keefe's death, and there is no evidence to suggest that Miss Reed was still upset about it on the night of January 28. Here, testimony by Laura Sullivan regarding the irrelevant and inherently prejudicial Aruba incident must be included because the witness has nothing to testify about other than an inadmissible hearsay and prejudicial character evidence. Indeed, during the 24 trial proceedings, the Commonwealth chose to put Laura Sullivan on the stand to testify about an incident that she did not witness in Aruba on December 31st, involving Miss Reed, Mr. O'Keefe, and her sister, Marietta Sullivan. Laura was also permitted to testify about her completely irrelevant negative impression of Karen during the planning of the Aruba trip. i.e. that Karen told her she needed her own bathroom and that she didn't want to share a room with John's kids. The Commonwealth then elicited additional inadmissible and prejudicial hearsay testimony from Laura, who told the jury that Mr. O'Keefe told her that Karen is crazy during a later conversation on the night of December 31st. And that on January 2nd, John insinuated that he was unhappy in their relationship. Note, this unhappiness was allegedly communicated non-verbally and solely via Mr. O'Keefe's body language, namely a shrug and an eye roll. Not only is this inadmissible hearsay, but it's an interpretation of a gesture, not an assertion of actual words that Mr. O'Keefe said to Laura, and thus calls for speculation. Yes. Notably, Massachusetts court had long held that the admission of hearsay statements for the purpose of showing a hostile relationship between the defendant and the victim is not permissible because it would entirely eviscerate. Didn't I just read all of this? The rule's important purpose of securing correctness and completeness of testimony through cross-examination. Thus, all of Laura Solomon's testimony regarding the Aruba trip constitute prejudicial and inadmissible hearsay, which must be excluded. For the above reasons, Ms. Reed requests the Honorable Court exclude any reference to December 31st accident in Aruba. Yes, I want to leave that side. Then we have defendant's motion to impound portions of defendant's motion in limine to exclude certain witnesses before and after testimony. Now comes the defendant, Ms. Reed, and respectfully moves the Honorable Court for an order impounding portion of defendant's motion in limine to exclude certain witnesses, namely the portion of the motion referring text messages that are subject to a protective order. So this is just because they brought some evidence in that they can't show because of protective order. And affidavit of Elizabeth Little to support this impoundment, not that important. Yes, and if she's paying for the room for the kids, wouldn't you like, especially if John likes to be out drinking at night, wouldn't you like to have a room you can put the kids in and they can stay there for themselves? They can watch Bluey. They are old enough to be in their own room. And when you have a bowel problem, I can understand. I didn't mind. I had my own hotel room when I was in Copenhagen. It's nice that you can just go home and sit for 45 minutes and scroll through Twitter while you're praising the porcelain gods. It wasn't a cruise. It was a resort in Aruba. Hey, Unbalanced. They normally won't allow red rum conviction because they are prejudicial, but Bev allow all of this bad character junk. Yes. And we all said it was absolutely stupid. But because it has nothing to do with the night of. It's the same. Lally constantly claimed that people witnessed an argument that they had in the car. No one said one word about any arguments on the night of. That's also something that he should have been admonished for, because he couldn't prove that there had been an argument. Everyone, 8 witnesses testified they were so lovey-dovey that one of them even got in trouble with his wife. Thank you, Baker, for going cross-eyed for us. We make jokes, but this is an incredible, important case. Yeah. Sadly, I can't follow as much in chat as I normally do because I'm in read mode. Jamie has a day off. Why isn't she here to help me? After she became a world traveler, she's just like, I don't hang out with you anymore. But thank you, Krista. Defendant's motion in limine to exclude certain witnesses before and after testimony. This is one of the better ones. Now come Ms. Reed and respectfully moves the court in limine to exclude certain witnesses from the courtroom. From the courtroom. Before and after their testimony at trial in this matter. Rule 21, sequestration of witnesses of the Massachusetts Rule of Criminal Procedure states, upon his own motion or the motion of either party, the judge may, prior to or during the examination of the witness, order any witness or witnesses other than defendant to be excluded from the courtroom. That's from Massachusetts Crime Law, P21. The power of a judge to control the progress within the limits of the adversary system, the shape of the trial is universally held to include the broad discretionary power to sequester witnesses before, during, and after their testimony. Reporter's note to Massachusetts Crime P21, emphasis added, citing Jeters v. United States, Holder v. United States, United States v. Robinson, United States v. Eastwood, Commonwealth v. Duggan, Commonwealth v. Watkins, Commonwealth v. Vanderpool, Commonwealth v. Blackburn, Commonwealth v. Folansby, Commonwealth v. Perry. Ms. Reed specifically requests that the court exercise this broad discretion to exclude Brian Albert, Coco, Colin Albert, Julie Albert, Chris Albert, Jen, Matthew, and Brian Higgins from the courtroom before and after their testimony at trial. As this court likely recalls, after the testified, members of the Albert and McCabe family proceeded to sit in the gallery with the O'Keefe family, facing the jury sporadically throughout the remainder of the trial, including closing arguments. Following trial, a juror reported to Vanity Fair magazine that he or she felt it was utterly inappropriate that the Albert and McCabe family were able to stare down the jury from their position in the courtroom gallery. One juror reported to Vanity Fair magazine that he or she felt intimidated by the presence of the Albert and McCabe family, calling their presence in the courtroom's small gallery facing the jury completely and utterly inappropriate. Noting that the Albert and McCabe family were substantial focal points of the trial, the juror noted how unbelievable it was for the family were allowed in to stare the jury down. Julie Miller, Karen Reed tells a story, part 2, Vanity Fair. And then there's a big redacted block here. This was extraordinarily prejudicial to Ms. Reed. The alleged third-party culprits, Brian Albert, Colin Albert, and Jennifer McCabe, all sat in the gallery during the closing argument, directly facing the jury, which, according to at least one juror, was intimidating. See Casiano, 70 Mass App, but I don't know what that is. Purporting that an act needed to be not overtly threatening to be considered intimidating. Gardner, defining the threshold of intimidation as what would instill fear in a reasonable person. Courts have recognized that when a witness or person stares down a jury, that can make the jury feel timid or fearful. See Commonwealth v. Gordon, defining intimidation as making timid or fearful, inspire or affect with fear, or to put in fear for the purpose of compelling or deterring conduct. Intimidation by the aforementioned witness in the context of this case took the form of staring down. Commonwealth v. Wormack, noting the jurors' intimidation during a trial where jurors were concerned to leave as there were a lot of people just kind of staring down and making the jurors uncomfortable. As previously noted, an individual does not need to do actual harm in order for the act to be considered intimidation. Gordon. As the jury heard through testimony, The Albert and McCabe family had deep connection and family ties to multiple state police forces and local governments. In addition, Mr. O'Keefe, a Boston Police Department officer, was a part of this tight-knit law enforcement community. By sitting with the family of John O'Keefe and continuing to face the jury for parts of the remainder of the trial, at least one jury felt intimidated by what he or she perceived as the Alberts staring the jury down. Here the judge has broad discretion to order the sequestration of witnesses before and after the testimony at trial. A defendant has the constitutional right to a fair trial to be decided by an impartial jury, free from intimidation and undue influence. Given that at least one juror reported feeling intimidated by the presence of certain witnesses toward the end of the trial, Ms. Reed respectfully requests the court exercise its broad discretion to issue a sequestration order excluding Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after their witness testimony to prevent further prejudice to Ms. Reed. For the above reasons, Ms. Reed respectfully requests that the Honorable Court exercise its broad discretion to exclude the named persons from the courtroom before and after. I believe this should be granted. I am reading all the motions so far that has dropped today in the Karen Reed case. A whole lot of stuff. This is for the upcoming case. They want to exclude the witnesses. They want to exclude the testimony from the Aruba lady, the two Aruba ladies. They want to bring in a chalk so they can show the glass pieces that was found around the scene. I think that's what we've done so far. Maybe I get to 6. Is he doing all 30? Brandon, you know me. I can go all night long. Well, we know how Andy Bev is going to rule on this one. Everyone will be denied except the one from the Commonwealth. This should get interesting. Well, the interesting part will when my voice will sound like I smoked 40 cigarettes. We could all make money in the bet Beving pool. No, because everyone would bet that Bev will deny everything. That was number 4. Yes, I want to leave this. This one I don't want to read. This is defendant's motion in limine for view. It's just that they want Ms. Reed states that permitting the jury to view the crime scene located at 34 Fairview Road and the vehicle at issue would assist the jurors to reach a verdict, allowing the impaneled jury to view the crime scene located at 34 Fairview will be particularly useful because the lawn appears to be much more expansive in photograph than it does in person. In addition, allowing jurors to visually inspect the vehicle will assist the juries in assessing whether John O'Keefe's injuries are consistent with having been struck by any portion of the car. They did this at the last trial as well. Remember, they took a day, went out there, the car was parked out there. It's just the same thing they want. This time, last time, the Commonwealth wanted that. This time, the defense want that. Why does Bev gag visual aids, chalks, demonstrative, etc. Did she explain before trial number 1? I can't remember that we covered all the motions in limine back then. I always pick the rest up in the morning. No, I give you $20 and say, grab a cab, see you later. They want to recreate the scene. No, they don't want to recreate the scene. This is the defendant who wants the car placed at Fairview 34, and then they want to see that. It's the defendant's motion. It's not the state's motion. It's like the last time. Remember, they had that morning where they went out there. The car was placed out there. They walked around for a bit, and then nothing happened. But this time, it's not the Commonwealth that wants to do it. It is the defendant. We have a challenge flag on the field. Well, I'm showing this to behind. I will do my best until my voice goes away. They have one trying to keep out proctor statements. I can't. I'm reading what I have. Valhalla could take over. Valhalla can't read. It's a sad thing, but sadly, Valhalla has severe dyslexia. Oh, it just came in. Well, I didn't get it. I don't know who normally puts it in our Discord chat, but I can't see it in my Discord chat. Defendant's motion in limine to prohibit testimony regarding funds paid to expert for purpose of voir dire. Again, we don't need to read this one. It's just that it is okay to ask about how much an expert makes per hour. I hate it, but it's okay. But they want to exclude, because Dr. Russell, the ARCA people, all of them accrued extra income because Bev forced them to do voir dire. And they mean they believe that they shouldn't be allowed to ask for that, how much they made, if it's something that was put as an expense on the defense by the court because they wanted them in the courtroom. What the hell? Sorry. Just checking if it was Marissa. But they just want to say, hey, it's not fair to say that instead of paying 5,000, we paid 10,000 because you made us spend 5,000 more to fly them out, put them in court. So you shouldn't be allowed to infer that, oh, these are highly paid experts and that's why they're biased. Rage is all fired up today. Well, a lot of people are angry. Everyone has excuses except me. I'm totally sick and disgusted with Bev. The motion for protective order ruled on without any defense input to protect the honor of certain witnesses. Yeah, the only thing that has been ruled on, I will show that as well, is of course a Commonwealth motion. The next motion is also just, this is standard. Karen Reed's motion for attorney-conducted panel voir dire. It's Ms. Reed requests the defense counsel to be permitted to conduct panel voir dire of the jury veneer, that's the jury pool, for the following subjects: whether previous experience with the jury system or criminal legal system, characteristic of the case, including the media attention, or personal characteristics or concern for the prospective juror would impair their ability to be impartial, whether prospective jurors are biased in favor of law enforcement or have law enforcement related knowledge, whether prospective jurors hold strong personal beliefs about operating a vehicle under the influence of alcohol, whether prospective jurors have been involved in or have close friends or family members who have been involved in domestic relationships, whether prospective jurors or anyone close to them have been involved in a motor vehicle crash, whether prospective jurors have been the victim of any violent crimes, and whether prospective jurors understand and can be impartial in light of the procedural protections afforded defendant in a criminal trial. Ms. Reed reserved the right to ask reasonable follow-up questions to each prospective juror pursuant to Rule 6.3c of the Rule of Superior Court 2017. This is the normal thing. We never see this. This is when the jury is empaneled. They will bring in 25 people and then they will ask all the questions. There will be a motion later from the state that says we want a written questionnaire just so they can weed out all the people that isn't beneficial to either side. They have the strikes, and but they can go through it easier if they have. Kind of like if Marissa is called for court duty, she can put in, oh, I'm a lawyer. She'll be chucked out faster than I got chucked out by my last girlfriend. Thank you so much. Unbalanced equation. For throat lozenges. I might need this today. But no court tomorrow, so I can just take the day off tomorrow. Jamie is retired anyway, so. Elsie said he would let Val fight one of his kangaroos as long as we have a way preventing it from. Don't orphan the goats. Well, the rule should be that Val isn't allowed to pass away, because I have no belief that Val could take on a kangaroo. Was there a lawyer on the first jury? I believe there was someone who had some legal. Again, we don't know. We have heard rumors that someone might have been a lawyer or something, but someone was a former law enforcement officer. He was the head of the jury. It would be awesome. Hey, Betsy. Australian vacation for all. Well, let's all go to Ohio. No, Brian, Jamie is home, but she got fancy feelings now that, oh, I've been to Europe. I'm posh. So she's not going to help me out anymore. She hates me now. Maybe it's because I drank my lord. Anything happened. So that was just a standard jury questionnaire. Defendant's motion for order prohibiting the Commonwealth and its agents for speaking with or having contact with any witnesses once they have taken the stand. This is a funny little one. Now comes the defendant can read, blah, 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 blah. To issue an order prohibiting the Commonwealth and its agents, including but not limited to the prosecution, law enforcement, and victim witness advocates, from speaking with or having any contact with any witnesses once the witnesses have taken the stand. During the first trial, the defense learned that the Commonwealth was having improper conversations with witnesses while they were in the middle of their testimony. For example, on cross-examination, Brian Albert indicated that he had spoken with Lally over the lunch hour while the court was in recess during the middle of his testimony. When asked what they had discussed, he initially denied speaking about the substance of his testimony, but then later admitted that Lally had discussed some of the topics he wanted to ask him on redirect. He maybe mentioned one thing he may ask me, just he was going to ask about what happened at the house in the morning. You know, some of the questions on redirect, that's all. As grounds for this motion, Ms. Reed states that the court has discretion to prohibit communications between witness and attorneys or third parties. See Perry v. League. In order to preserve the truth-seeking function of the trial, the court should prohibit agents of the Commonwealth from communicating with any witnesses once the witness has taken the stand. This is a particular concern during the recess or lunch break, in which there is virtually certainty that any conversation between the witness and the lawyer would relate to the ongoing testimony. For similar reasons, the Massachusetts Rule of Criminal Procedure permits a judge to exclude a witness other than the criminal defendant from the courtroom when they are not testifying. The sequestration of witnesses serve an important function to prevent one witness' testimony from being inadvertently molded by the testimony of other witnesses. The same danger that a witness' testimony may be molded by conversation with other is present when the witness speak with the prosecution or other agents of the Commonwealth during breaks in their testimony. For the above reason, Ms. Reed respectfully requests that they prohibit the Commonwealth talking with anyone. Isn't it funny how Lally didn't give 2 cents about the rules? And then there's a motion to impound defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and or intimidation of witnesses. We can't see that because it's impounded. So we don't know what this is about other than it's there. There are some gaps. You can see that there's all of these filings are numbered, and you can see there are gaps somewhere. And then we have an affidavit of Miss Little supporting this impoundment. Thanks for keeping me inside during the most beautiful day we have had in 4 months. Put it on your cell phone and get out in the sun. Enjoy the sun when it's out. I enjoyed our trip this weekend, and then I thought, oh, I'm going to wash all my clothes because it's sunny, everything's perfect. And then I put my clothes out this morning, and it was more wet when I pulled it in because it started raining. But thank you, Meat Hook. So go out, get some D vitamin. It's good for you. Stop being a size queen. Who's a size queen? Defendant's motion in limine to exclude serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation. Jamie? Extrapolation? I don't know what that word is. Extrapolation analysis. It's the conversion of the way they figured out how drunk she was at the time. They want that excluded. I don't know what that word is. Now comes, can read. Exclude evidence of a serum plasma ethanol concentration test performed by Good Samaritan Hospital at 9:08 a.m. on January 29th. By extension, Ms. Reed necessarily moves to exclude the blood ethanol concentration conversion performed by the Massachusetts State Police, as well as the corresponding retrograde extrapolation analysis. As grounds for this motion, Ms. Reed states that as acknowledged by MSP forensic scientist Nicholas C. Roberts in his report, the ethanol result used in the reports were provided by an external party. The testing to obtain the ethanol results were not performed in the Massachusetts State Police Crime Laboratory, and therefore the reports do not fall under the laboratory's scope of accreditation. Blah, 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 blah. Since the Commonwealth cannot establish that the blood test result administered by Good Samaritan Medical Center is reliable for the purpose of criminal prosecution, the serum plasma ethanol concentration results and the corresponding blood ethanol conversion and retrograde extrapolation, I'll go with that, which derived the result from the initial result, should be excluded as unreliable and not the product of reliable principle and methods. I think they tried this at the last trial, and she said, I'll allow it. On January 29th, around 7:26, Ms. Reed was admitted to Good Samaritan as a result of the acute grief reaction she experienced after learning that her then-boyfriend, John O'Keefe, had passed away. In addition to evaluating her, the hospital performed blood work and a urine drug test, which included tests for the presence of drugs and alcohol. So, a blood and drug test tested for drugs and alcohol. Amazing. Reed tested negative for any drugs for which the hospital screened. The hospital, however, recorded an alcohol level in Ms. Reed's blood of 93 milligram per deciliter. This is real numbers, so Americans might not understand them. Using the value from the test conducted by the hospital and without ever having applied for a warrant to themselves test Ms. Reed's blood, as would be normal course in a prosecution involving any aggravated form of operating under the influence, MSP performed a conversion of the reported 93 milligrams per deciliter result to a blood ethanol concentration ranging from 0.078 gram percentage, what the hell, to 0.083, based on 3 different conversions factor on May 4th, 2022. Using that conversion, Mr. Roberts then conducted a retrograde extrapolation on June 6, 2022. In both reports, Mr. Roberts explicitly notes that the serum plasma ethanol concentration obtained from Good Samaritan Center was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. After the first trial on September 17th, the toxicology unit administrative manual updated conversion factors used by the Massachusetts Crime Lab to align with ANSI ASB Best Practice Recommendation 122, first edition to 2024 document, per a new report dated October 10, 2024, authored by forensic scientist Hannah Knowles. The new serum plasma ethanol concentration estimated by the MSP Crime Lab is now between 0.078 and 0.082. October 10th report by Hannah Knowles. Moreover, in Knowles' report, she used a time interval of 8.5 hours with an additional 2-hour allowance for the time of 12:45 a.m., the time of the alleged incident, in an attempt to account for the uncertainties associated with the drinking history of the subject prior to the time interval. Her calculations determined that Ms. Reed's BAC could have been between 0.14 and 0.28 at 00:45 hours at the 29th of January. This range differs from the range testified to by the forensic scientist used by the Commonwealth at first trial, Nicholas Roberts, who indicated that the range would have been between 0.13 and 0.29. How much was this? It's a little bit off. This calculation assumes that the subject's BAC had peaked at or prior to the start of the time interval, indicating that the subject had consumed no ethanol half to 1.5 hours prior to the time interval. Because both the initial serum plasma conversion report and the subsequent retrograde extrapolation analysis are based on a blood test about which the parties lack essential information, including testing procedures and type of testing, the blood test results should be excluded. Retrograde exploration is a mathematical calculation used to estimate a person's blood alcohol level at a particular point in time by working backward from the time the blood alcohol test was taken, taking into consideration rates of both absorption and excretion. Commonwealth v. Senior. The SJC had held that, generally speaking, retrograde extrapolation analysis meets the Daubert-Lanigan standard for admissibility. Breathalyzer test results are generally admissible without the need for retrograde extrapolation, without the need for expert testimony when taken within a reasonable time, defined by the SJC as 3 hours, after operation of a vehicle. Commonwealth v. Coultery. Coultery lays out a narrow exception in which expert testimony is required, where the Commonwealth is proceeding under an impaired ability theory as opposed to a per se theory, and a test is administered outside of the 3-hour window. Necessitating retrograde extrapolation, expert testimony is required. Just last year, the Supreme Judicial Court addressed the issue of defendants' consent to a blood test in a prosecution for simple and aggravated forms of OUI in companion cases, Commonwealth v. Capellucci and Commonwealth v. Zucchini. The court held that the consent requirement of MGL C9024 1E only applies in prosecution for simple OUI under GL blah blah, rather than to any of the aggravated forms of OUI. Accordingly, whether Ms. Reed consented to the alcohol blood test or not is not at issue here. What is at issue, however, is that the parties lack essential information about how Good Samaritan Medical Center drew and tested Ms. Reed's blood. It is standard practice in prosecutions for OUI and its aggravated forms for police to request and be granted a warrant so that they can themselves test a defendant's blood through a certified analyst in accordance with the provisions of 501 CMR2, etc. While these requirements pertain only to analysts working for the state police and not the hospital personnel, see Commonwealth v. Dyer. They are in place to ensure that blood testing for ethanol undergoes a standardized, reliable, repeatable procedure. The admissibility of given test results will be governed by the adherence to the policies and procedures, and while strict adherence may not be required, any variance will certainly affect the weight given to the evidence by the fact finder. Regulations for the analysis of blood are contained in 501 CMR 2.18 to 2.20. The Massachusetts State Police utilize gas chromatography. This word. I don't know. Testing. That's it. Rather than enzymatic immunase. They're just taking the piss right now, right? Immunoassay. Sorry. I don't know. Testing, which presumably was used by the hospital here. In the medical records provided under the chemistry section, there is an annotation regarding the drug testing which state this report is intended for use in clinical monitoring and management of patient. It is not intended for use in employment-related drug testing or court-related proceedings. Samples are not routinely tested for odulation and are assured to be within the normal physiological pH range of 5 to 8. See attached page of Good Samaritan medical records. The alcohol result is beneath this annotation. It is not clear whether this annotation applies only to the urine drug screen or to the alcohol as well. Regardless, the defense should not have to guess. The Commonwealth should have, at minimum, provided documentation from the hospital regarding how the alcohol test result was obtained, through which procedure, by whom, and what manner of testing was used, i.e. gas chromatography. Jesus Christ. They don't have these words in Danish. We do, but we have a different language. So it'd be chromatography or enzymatic testing. I can say those words, but I have to guess how it is said in English. The latter of which would yield a higher result. Absent this information, the Commonwealth is unable to establish the reliability of this initial result on its face. In light of the fact the MSP, Mr. Roberts and Ms. Knowles each separately acknowledged in their respective reports that the serum plasma ethanol concentration tests do not meet the accreditation standards for reliability outlined in 501. We know with certainty that the serum plasma ethanol concentration test was at very least conducted according to an entirely different scientific protocol. Defense do not take issue with the generally accepted scientific practice of retrograde extrapolation itself, but rather with the data upon which it is based. Without reliable foundation information about the initial serum plasma result, the serum plasma conversion to blood ethanol concentration and the retrograde extrapolation from the converted number is not reliable. More precisely, the Commonwealth has not provided any information about the initial result from the hospital that would indicate that the subsequent analysis by Mr. Roberts and or Ms. Knowles are accurate. Instead, 3 parties involved in the BAC test has expressly disclaimed the legal veracity of these results. GLC 9024E1E states that a certificate signed or sworn to by a chemist of the Department of the State Police or by a chemist of a laboratory certified by the Department of Public Health, which contains the result of an analysis made by such chemist of the percentage of alcohol in such blood, shall be prima facie evidence on the percentage of alcohol in such blood. The analysis of Miss Reed's blood was not in fact made, at least not completely, by the chemist who signed and swore the certificate, as is admitted to in the reports by the MSP, Mr. Roberts, and Miss Knowles. In his testimony at trial, Mr. Roberts admitted that while the standard lab testing procedure is to conduct 2 separate tests within the laboratory, with Miss Reed's sample he conducted no testing himself and merely assumed that the hospital tests were accurate. Both of their analyses were conducted with data that did not themselves collect. Mr. Roberts himself confirmed that an unreliable base for calculations like we have here is a serious problem for the reliability of the explanation result. You do have to base the extrapolate on calculation on good. Your starting blocks have to be good, so you have to know the times in which the blood was drawn, the time of the incident, and essentially what your value was for your BAC. All 3 of Mr. Roberts' key factors are not clearly known. Moreover, the prior retrograde extrapolation was not in keeping with ANSI/ASB best practices, and thus the new forensic scientist Hannah Knowles has now issued a report with a new and different range of BAC, further underscoring the unreliability of the extrapolation in this case. Accordingly, the serum plasma conversion and retrograde extrapolation result should be included. Addressing the issue of pure evidentiary admissibility, GLC 23379 tells us that records kept by hospitals shall be admissible and may be admitted by the court in its discretion as evidence in the court of the Commonwealth, so far as such records relate to the treatment and medical history of such cases. Similarly, Commonwealth v. Dyer expand that medical records generated for evaluation and treatment purposes do not constitute testimonial evidence and may be admitted into evidence. Both the statute on point and seminal cases on medical record admissibility pose conjunctive requirements, treatment and medical history, and evaluation and treatment. The common factor between the 2 authorities is treatment. Ms. Reed's visit to Good Samaritan and the records produced, therefore, were explicitly not part of any process of the administration of medical treatment. Commonwealth v. Malone, decided the same year as Dyer, found that when the defendant's blood test was not connected to medical treatment, the Commonwealth's failure to meet the statutory requirements mean that the documented hospital records themselves cannot be admitted under GLC 23379 hearsay exception. Therefore, Ms. Reed's serum plasma ethanol concentrations results should be excluded for the above reasons. Blah, blah, blah. That's a lot of big words. I have put myself in the proper asses the case. Hit me with some questions and I will expose the truth Bev have been hiding for you. Thank you, Brandon. I am sure you have all the asses in the case lined up. And there's some big asses in this case. For some vitamin D capsules so you don't have to go out. Thank you, Unbalanced. And Doink the Clown says, those glasses look good on you, but come on, until you get a twine string belt, you're just half the man I am. Doink, I will never be half the man you are. I'm shooting for being maybe a quarter. But I will have to get that cheap weed so I can smell all the way, smell so much I can fill an entire courtroom. Extrapules tell more. Extra pull, please tell more. I don't know, Zach. 2 times? Whew. Sorry, I'm just trying to figure out which one of the news. I'm at 590, so whew, there's a lot more I need to read. This is a motion impounding witnesses' prior criminal history. Again, that's some personal stuff, so they're not allowed to talk about that. And an affidavit from Ms. Little saying the same thing. Commonwealth motion to appoint a court stenographer. It's just stuff they must do. Commonwealth motion in limine for sequestration order and relief, and for relief from that order for family members of the victim. This is one of the ones where I think they shouldn't be allowed all of them to be in the room, because there's I believe it's called the Marcy rule. I don't know if it's the same in every state, but there's the Marcy rule. The Marcy rule says that family members can be excluded from sequestration rules, but it doesn't have to be every single family member. They could make the order here that Peggy and William can be and watch the entire trial, which would be reasonable. But there's no reason why the niece and nephew, why the sister-in-law, and why Paul O'Keefe need to be in the courtroom. There's no reason for them to be excluded from sequestration. And they are witnesses, so we know she's going to grant it, because then Paul O'Keefe can sit over there and look angry. But I don't think they should be allowed to do it. Those glasses, I had that one. Oh, I'm so far behind. You have what on you, and where are you sending it? Thank you, Pro Gamer, for becoming a member. So they're not allowed to say Chris Albert unalive someone. That's not. We don't know what prior bad acts they are. And again, it was the defense who motioned to impound it. So it could just be that they are not allowed to disclose it before the trial. But we can't read it. If Karen Reed is somehow conflicted, there will be plenty of material for appeal at least. Just hope appeal court is not bad at Bev. Yes, I can see a lot of appealable stuff in all of these rulings. Then there's no reason for the brother to be in the courtroom. The defendant's brother, Nathan Reed, I don't know why he should be. I can't see why either Janet or Nathan shouldn't be allowed to be in the courtroom. They have nothing to do with the case. They weren't called as witnesses in the first trial. Why would the family not be allowed to sit there? Why should they be allowed to sit there? I don't care if they're family, if they're witnesses, they should be sequestered and not allowed in the courtroom doing any testimony. That's what you have the Marcy rule, so you can say the mom and dad should be allowed to be in there. But there's no reason why the nephew should be there. Yeah, I know he had adopted them, but there's no reason. There's no reason Paul O'Keefe's big old balls need to be on the screen every time. So I wish she would grant this, but she won't. Then we have the Commonwealth motion in limine to allow in-court identification. And this is a stupid thing. Someone is cranky. Marissa. Marissa don't agree. She wants the family to be in there. Well, I can't see what Paul O'Keefe has to be in there for. Nothing. He's a witness in the case. He's actually a pretty material witness in the case. So why should he be allowed to be in the room? He can tailor-make his testimony. I know they called him first the last time, but still. If they are witnesses, they shouldn't be there, even if they are parents. Well, isn't it the Marcy rule that says that family are allowed to skirt that thing? Why would it matter now? They obviously have watched the stuff from the first trial. Because the defense will more than likely bring something completely new to the scene. We know that the Commonwealth apparently have been out having some guy who's an accident reconstructionist. They didn't have that at the first trial. So a lot of things can change. They should be allowed to sit there until after his testimony. Well, it's even worse if he's there before he's testifying, because then he knows what... Well, we don't know if he was drunk the first time. That's just what he told his girlfriend. Well, it's because if you're sequestered, you are told not to do that. I know they do it anyway, but they should not do it. Well, this one I find stupid. The Commonwealth moves in limine to allow an in-court identification of the defendant in accordance with the rule announced on December 17, 2014 in Commonwealth v. Creighton and Commonwealth v. Collins. In Creighton, the court ruled that where an eyewitness did not participate, as Marissa said, an eyewitness did not participate before trial in an identification procedure, good reason for an in-court identification must first be shown. The court based the new rule on common law principles of fairness and did not address the subject under state constitutional principles. The court ruled that this rule also applies where an eyewitness to a crime has not made an unequivocal positive identification of the defendant before trial. While the court did not categorically circumscribe when good reason might exist, the court provided the following two examples of good reason. The eyewitness was already familiar with the defendant before the commission of the crime, or the eyewitness was an arresting officer who was an eyewitness to the crime, and an identification would merely confirm that the defendant is the person who was arrested from the charged crime. The court explained that these circumstances, the witnesses would not be identifying the defendant based solely on his/her memory of witnessing the defendant at the time of the crime. While there are 0 eyewitnesses to the crime itself, witnesses observed the defendant close in time to the crime and in the subsequent aftermath and recovery of the victim's body. The circumstances here meet good reason standard. As in Creighton, there are no out-of-court identification procedure conducted prior to the trial. The Commonwealth intends to lay a foundation that the witnesses were familiar with the defendant prior to January, the date the defendant is alleged to have unalived John O'Keefe. The Commonwealth's witnesses, including individuals who were friendly with the defendant and knew her through her relationship with the victim. This is not a case where a particular witness is identifying the defendant based solely upon his or her memory of witnessing the defendant around the time of the crime. As the court stated in Creighton, under these circumstances, where witnesses knew the defendant prior to the crime, there is little risk of misidentification arising in court, the in-court show-up. Further, the facts support that there are good reason for the police officers and first responders who interacted with the defendant at scene at the hospital and at subsequent interviews to be permitted to make an in-court identification of the defendant. For this reason, the Commonwealth motion in limine to admit in-court identification should be allowed. So he wants everyone to be asked, do you see the defendant here in court today? Yes. Can you point to Karen Reed? Yes, she's sitting right there. This isn't a case about I wasn't there. I don't know why they want everyone, and he's going to do everyone must say this is the one who did it. I can't see why that should be a part of this case. I don't know. Supposedly, the trolls found out that the defense expert Green was arrested years ago and put out his mugshot. Oh, that's an old one, and I think that was debunked. And again, it has nothing to do with anything. Yeah, and it's super prejudicial to everyone say, oh, at the time of the murder, did you know Karen Reed? Is she present here today? Or he's going to bring in a whole new witness who didn't testify in the first trial. Could be. I don't know why. Again, I can understand it in a case of I wasn't there. But she admits she was there. She admits she drove the car there. It's just so you can have everyone point at her and say she's the defendant. Highly prejudicial and stupid. It's one of those shady tactics, that they just want to prejudice the jury even more. He's the guy who was crying about polluting the jury pool, and now he want to do this in open court. I'm about to swear a lot in my yard. Swear jar for my neighbors. Thank you, Marissa. I will accommodate. Again, if you have someone who said, I saw a person there, can you see the person in the courtroom? Yes, this is the person sitting right there. But that's not this type of case. That was the case we had with the bike killer. Yeah, but he wants everyone to do it. Yeah, motion to have wit. Can she wear a sign saying, I'm guilty, Your Honor? Can we have a motion? Yeah, the identification of Karen Reed is actually done every day in court because she says, good morning, Miss Reed, and she answers, good morning. So Bev can just say, is Miss Reed present in the courtroom? Then you don't need any identification. Well, get Brandon's phone because he needs a new phone. Next one. Commonwealth's motion in limine to preclude reference to and redact the manner of death contained on the victim's death certificate. This is a little sleight of hand as I read it, because we all know what the death certificate says. And this is quite a big problem for the state, because they want to redact the means and manner of death. In this case, the means and manner of death on the death certificate is undetermined. This is why they want to remove this from the case, because he's gonna yak on about, well, you can say that either it's murder, it's homicide, or it's accident, but in this case it's undetermined. So it's the better and safer course not to mention it. No, this is because you really don't want it to be undetermined, because on cross in the last one, your medical examiner had to sit there and say, so You look at if you believe it's a homicide, a suicide, an accident, or whatever. And that removes homicide and accident. I know that, and suicide. But the important thing that takes out is the homicide, because he wants to allude that, well, it's a murder. But even his own medical staff couldn't determine this is a murder. That's why he wants this thrown out. And Emmy has already testified in first trial. It's undetermined is accurate. Yeah. But Bev will say, it's a second trial. Now you need a swear jar. Well, I'll stuff you right in the jar. Thank you, Krista. I'm sorry, Dippy-Doo, Brennan. Your Emmy was bullied to get her to switch it, and she wasn't having it. Yeah, remember, you couldn't even get her to write the right thing on the death certificate. That's also in the communications from Proctor. Because we don't play fair. The Emmy even states Johnson's injury is not consistent with a car crash. Yeah, there's a lot of things that they really want to keep out of here. Dr. Squirty Bellow, exactly. That's her name. The next one. This one I need some help with because just we not that smart. Commonwealth's motion in limine to introduce certified records from the Registry of Motor Vehicles. Commonwealth respectfully requests that this court issue a ruling in limine that the Commonwealth may introduce certified copies of records from the Massachusetts Registry of Motor Vehicles for Massachusetts registration number 3GC684. What? Whose car is that? Is it to prove that Karen Reed owns it? It's not a disputed fact. Is it the car that Paul O'Keefe drives around in now that his brother used to own? What? There's no question about any of this. So we're going to look at a DMV report. Purchased by, owned by. Why? Can any MG, can you give me a good reason why you need this? Is she also going to try and exclude Proctor's text messages about the ME being a whack job because she wouldn't write on the certificate what he wanted? She point blank refused. Kirk's, that's the thing I think he want to circumvent by removing the manner and cause of death. There's no question about the ownership. And I don't know if it's Karen's car. They're gonna get Pill to confirm it was busted real bad when he got it. Proctor? I don't know. Who? Paul. Yeah. Hank has to look busy somehow. He can't say he got all his info from hearsay. That's yeah. Hey, Luna. Yeah, I don't know which car this is. Some local snoop probably have the pictures and right at hand and can find out. But I'm just, why do you need the motor vehicle records? Because again, it doesn't prove anything. We know the make, we know the model, we have the car. Unless it's someone else's car that got a speeding ticket on a camera and who drove behind Karen Reed, and that's why they can prove that this person saw her cracked tail light. I can't see why you are getting. And imagine the time it takes to get the DMV to send you a report. Whew. Oh, it's Karen's car. Then why are we doing this? How do we even know that Karen was the one to drive John to Fairview? We only have Nagel's word for it. It's possible John drove and then Karen got in the driver's seat to drive home. How do we know they had a big argument in the car? Lally says so. If I had money to put in a sweat jar, I would be a millionaire. Yeah. But does it matter whose car it is? Was there a question about the custody of the car? I'd be more concerned than wins match. No, there's no. This is the Commonwealth, so it's not because and the car is impounded, so there's nothing. I just don't understand why we are going to get a DMV. Oh, Karen said she drove. Yeah, no one is saying it's not her car. Well, that's the thing. If you use things in a crime, or even if you are suspected of using things in a crime, you'll still have to pay for it. In Denmark, if you drive 100% above the legal limit, police will just confiscate your car. It doesn't matter if it's some car you borrowed, if it's a leased car, it's a car you have you pay the bill for. They'll confiscate it. They'll sell it. You will have to pay the rest. That's the law. 100% or above, you'll lose your car instantly, and you can't get it back. We had a guy who did it in a $3.5 million. I believe it was a Ferrari. He tried to go to the courts and say, I want it back. You can't confiscate. It's too expensive. They said, well, the law's the law. 100% or more above the speed limit. We have a law that says we're going to confiscate your shit. He had it in less than a day and paid $3.5 million for it. If he's trying to establish chain of custody, it's too late. No, you can just backdate all your reports. It's no problem. It was Matt and Jen that claimed that Karen and John argued. No proof whatsoever, just their lying words. Yeah, but that was before trial because they didn't testify in trial. No one testified they were arguing. We know from the text messages they had kind of a heated argument earlier in the day, but nowhere near, I'm going to unalive you with a car later. Could be something like that. Interesting. This was that one. Commonwealth motion in limine of intent to obtain Corey records of the potential jurors. This is the same as the last time. They want the criminal records of the jury to see if they should be allowed to be jurors. And someone might have a sneaking suspicion it's to do some background checks on the jurors that they could potentially use for something else. But again, it's also, as I understand it, a normal procedure. And then we have Commonwealth's motion for offer of proof prior to defendant calling or summarizing the Norfolk District Attorney and victim witness advocates as witnesses, and request for an order that neither is subject to a sequestration order. This is a fun one. Now comes the Commonwealth and move that this court order that the defendant make a satisfactory offer of proof prior to calling Norfolk District Attorney Michael Meatball Morrissey and victim witness advocate Stephen Nelson as witnesses, and for a finding that the district attorney and Mr. Nelson are not subject to any order of sequestration. It's about Morrissey and Nelson. On March 6, the defendant listed both the district attorney and victim witness advocate as potential defense witnesses. When a defendant resorts to an extraordinary means of calling a prosecutor as a witness, he must make a satisfactory offer of proof as to the need for testimony from the prosecutor. Commonwealth v. Blakey, maybe? Compare in re enforcement of subpoena 436 Massachusetts 784. Generally, witnesses has a burden of showing why the subpoena should not be enforced. A prosecutor should be called only where there is a showing that the prosecutor's testimony is relevant, material, and not cumulative. Defendant failed to show that prosecutor had personal knowledge of relevant factors bearing on officer credibility that could not be elicited by other means. The same principles holds true for the advocate. See Commonwealth v. Bing Zai Liang, 434 Massachusetts 135 132 2001. Victim witness advocate is member of prosecution team and notes discoverable or protected by work product rule to the same extent as prosecutors knows. Yeah, especially because Michael Morrissey have inserted himself into this case. Remember when he said all of our witnesses is 100% believable? He must then have personal knowledge of this. District Attorney Meatball is an elected official of the Norfolk District, a position he was first elected to in 2010. As such, he is the elected advocate of the people and the chief law enforcement officer from the Norfolk District. Blah, 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 blah. District Attorney is the people's elected advocate for a broad spectrum of societal interest, from ensuring that criminals are punished for wrongdoing to allocating limited resources to maximize public protection. Mr. Nelson is an employee of the Norfolk District Attorney's Office and is assigned to victim witness advocate in this case and has been assigned to the case since January 2022. Filing 434 Massachusetts Victims Bill of Rights generally requires the staff of the district attorney to ensure the victims and witnesses are afforded such rights. Commonwealth v. Harris. The victims' advocates serve an important salutary function. They provide victims, witnesses, and family members needed assistance, information, and support, and generally help them to cope with the realities of the criminal justice system and the disruption of personal affairs attending a criminal prosecution during a time of personal trauma. During trial, it is especially important that the advocate engage in the essential function of acting as a liaison between victims and witnesses and the district attorney's office. Neither the district attorney nor the advocate were participant witnesses to the charges before this court. To the extent the defendant may want to impeach proposed Commonwealth witnesses as to the statements, the defendant has not shown the absence of alternate sources of said purported information. Further, to the extent the defendant is seeking either the district attorney's or the advocate's opinions or observations regarding witnesses' mental impressions, research or evaluation of the evidence for the Norfolk County case, such areas of inquiry reflect privileged work product. See Baisial Ling. Generally flatly, also Massachusetts Rule 14, work product rule exempts from discovery those portions of records, reports, correspondence, memoranda, or internal documents of the adverse party which are only the legal research, opinions, theories, or conclusions of the adverse party or its attorney and legal staff. Therefore, the Norfolk County District Attorney's Office respectfully requests that this court order prior to calling or summarizing the district attorney and advocate, the defendant make a satisfactory offer of proof before this court, and that this court finds that they are not subject to any order of sequestration. Just like D.A. Gravely did in Zach Anderson's case. Yeah. What was it? Jen McCabe who kind of made the victim's advocate a witness? Didn't she say something about what was it she said? I'm pretty sure it was him or her who said something about him. And Morrissey clearly didn't just have mental impressions about his witnesses. He vouched for them. He said all our witnesses are innocent. They didn't do anything. Yes, and it is submitted by the Commonwealth Meatball Morrissey. He didn't sign it, but the team did. But again, it could be fun, won't happen. That's where I say this isn't just a work product. He didn't just sit at home and talk to Lally and say, "Well, I think Jen is highly capable as a witness, and she's clearly unbiased, and I believe her truthfulness." No, he went on camera, said, "It gotta stop. This witness intimidation gotta stop." He clearly didn't keep it on the advocate team. He went to the public. He poisoned the well. Yeah, just have find her guilty. And Bevel has said, "I'll allow it." The next one is Commonwealth motion in limine requesting use of chalks and directing both parties to provide visual presentations and chalk prior to using. They request that they allow computer-assisted technology to display exhibits and diagrams as chalks or demonstrative evidence, and any excerpts of voluminous video recordings. Yeah, you find those all the time. This Commonwealth seeks to use the following: surveillance videos, photographs, videos from the crash reconstruction, videos from the reconstruction at One Meadow Avenue, diagrams of the scene and roadway, and diagrams and digital forensic extraction reports to be projected onto a screen by computer. It's just a lot of crap. A trial judge has it doesn't. They just asked to be allowed to show it on screen. The same motion, kind of that the defense used in the beginning. Oh, maybe that's yeah. I don't. But they just wanted to be allowed to show exhibits. Then they want to have another go with their Cellbrite expert. They want to call Hyde and Whiffen again, and they want Whiffen to conduct a courtroom demonstration on how data was stored within Jennifer McCabe's cell phone. And then they say Mr. Whiffen is a senior digital intelligence expert for Cellbrite. Do any of you know I think it's I don't know if you call it an operette as we do, Pinafore. I believe it's in that one where they say titles is something you give to idiots but he is a senior digital intelligence expert. We were told what his profession was. He goes around, demonstrates this crap, and then he tells the nerds back home what the customer wants. He's a sales rep, but he got a fancy title, so when he goes out, because modern business is full with BS, you need a fancy title. That's why I don't know if you have the same thing in America with this. Titles are just exploding. You are not a nurse anymore. You are an anesthetic specialist, or you are a wound care expert. You're not just a nurse like you were back in the day. It's the same with all of these idiots. He's just a sales rep, but he got a fancy title because then it sounds better when he talks to another guy who also went to a school and thought, well, I am head of acquisition. There's only one guy who buys stuff for this company, but I'm head of acquisition because it sounds fancy. Get shit all extra in pay, but I got a fancy title, so I can put it on Tinder and the ladies might love me. This idiot, no, he's not an idiot. He's smarter than I am. But remember his demonstrative the first time. I didn't understand crap all. Nothing. Because it's all the vaps and the whoops and the dips and the hashtags and the whatever. It's I don't know what if any reason there is. I think Karen needs more fiber, so many motions and dumps. Today she needed, there was, I think we are close to 40 dumps today. Bev didn't allow in any of Microdot's work that he did in preparation for the trial, including the cleaned up 911 call where we hear Jen talk to Nicole, which Jen denied. Yeah, isn't it funny that none of the demonstratives from the defense was allowed, but this guy was allowed to sit in a courtroom and say, well, I do this. How can you prove it? Yes, I know SDIEs. If you had me on the show, I could explain it to you in terms that non-pot smokers might understand. Doink. Hit me up in DMs, you'll get a link. We may need a bigger swear jar for Karen Reed Part 2. Yeah, I need one of those big Chinese things. They weren't worried about emails because they think they're above the law. Exactly, and that's how they get caught. When you get careless, or when you start using your personal email, because you can't use personal email in any way connected to your job as a government official, because you have an obligation so everything can be FOIA'd. I don't know how the rules are in the US, but if you use your personal email to do government business, isn't everything on your email then potentially searchable? I don't know. You could probably swing that in court. Yes. Doink, 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 the clown. Resident Internet Airhead, the expert, has got me like 40 subs in the last week. What a guy. Well, I wanted people to share your link the last time you talked about subs, but the ladies said we don't like him. You can, it just subjects your personal email for FOIA and subpoena for cases. Yeah, that's what I believe. If you just send one email, then all of those other emails that you got from that site where you met that nice Venezuelan boy, they will also all of a sudden be public. Yeah, they were all busy. Hey, Food Fairy. The Commonwealth provide notice that it intended to call Whiffen, blah, blah, blah. Whiffen is the senior blah, blah from Cellbrite. Cellbrite is the leading forensic digital extraction software tool that provides examiner with the ability to access and analyze data stored within a digital device. Remember, you can't trust Cellbrite. The Cellbrite software allows an examiner to pass the layers of data through different methods of extraction and analysis. Also, Jessica Hyde will use a courtroom demonstration to show jurors information and data on both Jen McCabe's and John O'Keefe's phone to explain concepts and to illustrate particular information of importance about each respective phone's data. Jen McCabe provided her cell phone to law enforcement in the days following John O'Keefe's death. Cellbrite software was used by Commonwealth and the defendant's expert to interpret the digital data. Cellbrite extraction reports are computer-generated records and do not implicate the rule against hearsay. In Ms. Whiffen's expert reports provided to the defendant in 2023 and 2024, Mr. Whiffen utilized his superior knowledge of Cellbrite software to demonstrate how, where, and when Jen McCabe Google searches were stored within the digital database. The Commonwealth moved to permit Mr. Whiffen to conduct a demonstration using Cellbrite software to enable the jury to better understand the digital forensics. It is within the sound discretion of the trial judge to permit a courtroom experiment. Again, it's nothing. The Commonwealth intends to have Mr. Whiffen use the highly disputed extraction report from Jennifer McCabe's cell phone to demonstrate with Cellbrite software how, where, and when the digital data of the Google searches was stored. This demonstration would closely mirror the actual Google searches conducted by Jennifer McCabe on January 29th and would aid the jury in understanding how Mr. Whiffen is able to opine that the contested search occurred at approximately 6:24 and not 2:27. Lay witness testimony that a black article of clothing could appear light-colored when viewed at night using the type of surveillance system. It's something stupid. Notably, the defendant does not dispute the reliability of the Cellbrite software, and her own expert has relied on Cellbrite to draw their conclusion. No. Your expert has said Cellbrite isn't reliable. Your expert said, you can't only use Cellbrite. You need to use my program to understand Cellbrite. I didn't do all the other searches that the defense did and used those programs. I only used my program that you can get for free on his Swiss, I believe it's a Swiss website that more than 70 people have downloaded so far. Cellbrite's expert is such an expert in Cellbrite, he doesn't believe Cellbrite works. And then they mentioned the Rentala case about a drying time of paint was not sufficiently reliable in murder cases as there was no scientific and technical basis for opinion and lack of sufficiently reliable methodology. In addition, both Mr. Whiffen and Ms. Hyde would use demonstrations to articulate and explain important data information contained on both Jen McCabe's and John O'Keefe's phone. The proponent may use a summary chart or the like to prove the content of voluminous writings and records that cannot be conveniently examined in court. Parties should consider authenticating admitting excerpts when digital evidence is voluminous, and jury may find it difficult to master the technology to find and view relevant portions of the evidence. The use of a Cellbrite demonstration by the expert, who is the senior digital examiner for Cellbrite, again, he is a fancy sales rep, would serve the essential truth-seeking function of the jury, and the demonstration would be relatively short, concise, and without unnecessary technical language as not to confuse the jury. Again, Michael Morrissey. I don't believe he should be allowed to do it. If he should be allowed to do it, I know this isn't how you do things, but then the defense should be able to put their expert right next to him and show where they believe he's mistaken. Because they weren't allowed to show how they got to their result. Which I find is very very biased of Bev. I know it comes as a surprise for many of you that I find Bev a little bit biased. I used to be the vice president of employee operations and office management. I work for my family. There are 3 of us. Lol. I was the office manager. Well, I am the slave in the worldwide JNN network. Owner, operator, head CEO, SEO, SFO, head of acquisition, head of HR is Jamie. Pay tomorrow is what she says every time I ask, when am I going to get pay? She says, pay tomorrow. She has all the titles. I'm just a slave. I'm a slave to you. Yeah. So many hats, but luckily enough, nothing has opened more than 1 minute, and everything goes to voicemail. I'm not the head of mergers. I'm not allowed to do anything. I am run by the trio of women, head of communications, acquisitions, and reaching out to guests, and stealer of court records, and yeller when Jamie is tired. Those are the three ladies taking care of me. This one has a surprising headline. Commonwealth's motion in limine to admit the victim's out-of-court statements relating to his state of mind. Karen Read has changed her gender. Oh, the victim. Sorry, I read for better. It's been a long time. 2 hours. I read a lot. The Commonwealth moved the Honorable Court to allow into evidence John O'Keefe's statement to his niece, nephew, family members, and friends regarding the defendant's intention to end his relationship with the defendant, and statements about the tumultuous nature of the relationship, which are relevant to the victim's state of mind. The broad rule on hearsay evidence interdicts the admission of a statement made out of court which is offered to prove the truth of what is asserted. Commonwealth v. Dalle Valle. However, declaration out of court may be admissible to prove the state of mind or intent of a person where it is a material issue. Commonwealth v. Quails. The state of mind exception to the hearsay rule calls for admission of evidence of a murder victim's state of mind as proof of the defendant's motive to kill the victim when and only when there also is evidence that the defendant was aware of the state of mind at the time of the crime and would be likely to respond to it. This part I would love them to prove. All of this, because none of this was proven in the first trial. She wasn't aware of anything. Nothing like this. They didn't even try to get this into the case. She was not aware that he had made statements to his family, friends, dog, postman, that he wanted to leave her. So this should be thrown out faster than I can go through a buffet. A murder victim's attitude or contempt or hostility toward the defendant when it is known to the defendant would constitute some evidence which, augmented by other evidence, might warrant a fact finder's determination that the defendant responded by killing the victim. Quails. There need not be direct evidence that the defendant learned of the victim's state of mind, as long as the jury could have reasonably inferred that she did. My neighbor is probably wondering why I am screaming in my room. Everyone, please go back to May of last year. I believe it was May. I had just returned from wonderful Tennessee, and we had that day in court where Lally introduced text messages between Karen Read and John O'Keefe. I think it was, I'm not sure. I read every single one of those text messages. That text message thread showed that John O'Keefe was an asshole to Karen Read that day. it seemed like he was the jealous type because she wouldn't let him come and fix her boiler. I don't know if it's a euphemism that he was afraid that the guy down the road would fix her boiler. That text thread showed that he had been out drinking the day before and just woke up and was ready to go out drinking again. And he begged her to come to Canton. She was playing the annoying thing women do where they said, well, if you don't want me to come, I won't come because you want us to beg you to come. Was it sunshine and rainbows? No. I don't think they had a great relationship. I don't think that they were just about to get married. No. I think they had a relationship. Probably a relationship that wouldn't go much further than we like to hang out with each other. When we're together, we are having a great time, but it's probably not going to be more than that at any point, which is great for people who are a bit older. We don't need to cohabitate with anyone. I myself like the thing where you can say, okay, let's do something together. Please piss off. Because it's not all the time you're getting older, you get set in your ways. I do this for way too many hours a day. So I like to be able to kind of say, okay, I want to be in this mode and I want to be in this mode. And I think that's kind of the relationship they had. They had each their houses. They had a relationship that was a bit rocky. Yes, to me, he seemed more jealous than she did. But I also saw the video of the night. And I heard 8 people testify. They were lovey-dovey. We heard the Portuguese guy say, they were so lovey-dovey that my wife begged me to be more like them. Now you want to put in that, well, he told everyone in his family that he wanted to dump her. And by those statements, you want to prove that she knew and then she chose to unalive her. Him, sorry. If this isn't thrown out, I don't even think I'm going to cover the second trial because Bev is, then she's worse than I thought she could be. This is ridiculous. There's nothing in this case that proved that the hearsay rule should be overruled. It doesn't matter that she said she was tired of being a glorified babysitter. Doesn't matter. It doesn't matter that he said, yeah, I'm getting quite sick of that old ball and chain. You need to show that she had knowledge of it and that's why she chose to unalive him. Not one person testified that there was any bit of any bad blood between these two that night. We saw the text messages. He was the big asshole in those, as I read it. And yes, I admit, it didn't come off as 2 14-year-olds in love. No, it came off as he was a bit needy. He was probably hungover. And she was also needy and wanted him to beg her. Happens every day. Animosity. That's the word I was looking for. The Commonwealth's intent to introduce statements the victim made to his family members and friends close in time to the red rum about his relationship with the defendant and his decision to terminate the relationship. Their relationship was ongoing. He begged her to come. He begged her to stay. Could be just because he wanted a booty call. But he didn't say, "Don't come, I'm breaking up with you." The Commonwealth also intend to introduce the victim statement through text messages authored by the victim and contained within the victim's cell phone that express his decision communicated directly to the defendant to terminate their relationship. You tried to do that at the first trial. That's not what they say. If you don't want to be here, blah, 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 please make the boiler guy. Are we ending this? She was the one asking if this was over. Jesus. The defendant and victim's relationship had deteriorated, and the defendant also made similar statements about the discord and disdain in their relationship, and the defendant herself had begun to engage in romantic and flirtatious communication with other men. Yeah, of course, let's get Higgins back on the stand to testify how she gave him the ghost treatment. When I heard how all of this romantic relationship between her and Higgins, the affair, happened, guess who jumped to my potential most suspect if I was to look for a murder in this case? Because she ghosted him. She just wanted the affirmation that I'm still hot enough to pull a guy. And then he started to think, oh, we're going to do the relationship thing. And she said, deuce, I'm out. Where was I? Yeah. Commonwealth v. Castano, adequate evidence for the jury to infer that the defendant was aware of the victim's plan to end the relationship. Where? Commonwealth v. Cruz, proper evidence of threats and discord in relationship demonstrated respective states of mind of victim of defendant. Commonwealth v. Weichel, defendant's statement and actions including heated argument with victim in weeks before murder permitted inference that defendant and victim had communicated hostile intention towards each other. Commonwealth v. Borodin, defendant's statement to others concerning argument with victim over their relationship coupled with victim's willingness to tell third party that her relationship with defendant had deteriorated permitted inference that defendant was made aware of victim's state of mind. Whereas the defendant has repeatedly accused others of committing red rum, the jury should be permitted to consider all evidence that demonstrate the relationship and hostility between the defendant and victim at the time of their murder. Castano, where the defendant described the murder as an accidental shooting, the piece of evidence and victim statements considered together and in context of the location and manner of the victim's death provided the jury with sufficient foundation to reasonably infer that the victim made the defendant aware of her desire to end the relationship. The probative value of the victim's statement is relevant to the defendant's motive to kill him. The probative value of these statements outweighs any possible prejudicial effect of the statements are being offered only to prove state of mind and not to the truth of what was stated. Any potential prejudice could be remedied through a jury instruction on the limited use of state of mind evidence. No, go fuck yourself. You just want to say their relationship was ending because you don't have anything. You don't have nothing. No injuries could potentially line up with that either. John O'Keefe was not hit by a vehicle. Commonwealth's motion in limine to admit results of defendant's blood draw at Good Samaritan Hospital, resulting seroconversion and retrograde extrapolation. Now comes the Commonwealth and respectively moves the Honorable Court in Limine to admit evidence about the defendant's blood draw at Good Samaritan during the course of a medical treatment and the results of the blood alcohol serum conversion and retrograde extrapolation to establish the percentage of alcohol in the defendant's blood, CGL C9024-1E, a certificate signed and sworn to by a chemist of the Department of the State Police or by a chemist of a laboratory certified by the Department of Public Health, which contained the result of an analysis made by such chemist of the percentage of alcohol in such blood shall be prima facie evidence of the percentage of alcohol in such blood. Commonwealth v. Senior. Retrograde extrapolation is admissible evidence and satisfied Dorbert Lanigan. The defendant's medical record of the blood test is admissible under GL C233-7. Pursuant to the statute, records kept by hospitals shall be admissible and may be admitted by the court in its discretion as evidence in the courts of the Commonwealth so far as such records relate to the treatment and medical history. That's the treatment part that the defense pointed at didn't happen. Of such cases, and the court may in its discretion admit copies of such records if certified by the person of custody thereof to be true and complete. Commonwealth v. Dyer. Medical records generated for evaluation and treatment purposes do not constitute testimonial evidence. The Commonwealth anticipates that the medical providers who participated in the blood draw will testify to their knowledge, training, and expertise in how the tests were administered to demonstrate their reliable basis in the knowledge and experience in the discipline. Additionally, witness will testify about blood alcohol serum conversion and retrograde extrapolation to establish the percentage of alcohol in the defendant's blood at the time she was driving her SUV and struck John O'Keefe. Blood alcohol serum conversion and retrograde extrapolation is admissible. See Commonwealth v. Hallingman. Again, Morrissey. It's just an answer to the defense. They knew that was coming. Motion to preclude reference to any alleged bad character or any prior misconduct of witness, victim or witness. Moves this court to order counsel to refrain from making any reference before the jury of any alleged bad character. This is the one to keep out Chris Albert's prior bad accidents, or alleged misconduct of the victim or any witness without prior court permission, or call it maybe. Specifically, the defense has made allegations about civilian witnesses and law enforcement witnesses, and the public has been saturated with unfounded claims of bad acts by the Commonwealth witnesses. At the previous trial, the defense lodged a slew of claims of alleged bad acts of witnesses. Indeed, the defense has engaged in a comprehensive campaign to inundate the public with its claims and has repeatedly declared or implied that the Commonwealth, the prosecutors, the court, trial court employees, and witnesses are corrupt, declaring that virtually every civilian witness, police officer, and first responder was complicit in a cover-up of evidence and implying that nearly every witness is a liar. I would really, really like to see evidence of this. Defense comprehensive campaign. Do they have any proof that the defense are the one who implied the Commonwealth, the prosecutor, the court, the trial court employees, and witnesses are corrupt? Are they saying that Aiden acts as an agent for the defense? I believe a grand jury heard the evidence of a conspiracy between Karen Reed and Aiden Carney. No charges were brought. Now we have, again, in official court record, claims that the defense have done these things. Didn't he just retract something kind of like this the last time we were in court. Such allegations has no foundation or bearing on any issue in this case and would constitute impermissible bad character evidence, whether during the opening statement, during cross-examination of any Commonwealth witness, during direct examination of the defendant's witness, or during closing arguments. Defense counsel should be restrained from making such reference unless obtaining prior court approval. A judge may properly exclude evidence that is introduced merely to show the bad character of a witness. Further, evidence of prior misconduct may not be used to impeach a witness' credibility, except by producing by production of records of criminal convictions pursuant to the limitations and requirements of GLC 233-21 Commonwealth v. Clifford, Commonwealth v. Turner. Trial judge has the sound discretion to determine whether prior act evidence is relevant and whether the probative value of such evidence is outweighed by the prejudicial effect. Commonwealth v. Stote. The judge's determination will be upheld absent palpable error. No error where judge excluded evidence regarding victim's bookmaking activities or prior arrest. Commonwealth v. Weichel. Wasn't Weichel an Ice Age? Judge probably excluded evidence that victim stole a watch of the defendant. Impeachment by a prior bad act that demonstrated lack of character is not permissible and invites misuse by the jury. Commonwealth v. Podkova, maybe. No error when judge excluded evidence that witness was not a good mother in an infant homicide case, even where defendant claimed witness was the real perpetrator. Evidence irrelevant to this issue at trial or to a witness' reputation for truth or veracity is inadmissible to impeach a witness. Commonwealth v. Cancel. Any bad character evidence of infidelity, propensity to consume alcohol, or the defendant's suggestion without any factual support that every witness is a liar or participant in an unfounded scheme to frame the defendant has no bearing on any of the issues raised to this case. Any bad character evidence of infidelity. Have we heard anyone talking about infidelity in this case? Are they afraid that some of the witnesses might propensity to consume alcohol? Well, if a cop is so drunk they lose their badge, shouldn't they be allowed to talk about that? The defense should not be permitted to introduce bad character nor specific bad acts of the victim or any witness. The proposed evidence only serves to disparage the victim and witness character and distract the jury. Comes from you assholes. Isn't the exclusion of bad character evidence only applicable to the defendant? This is talking about and conflating impeachment evidence. Well, it's also to... You can't... You probably can't bring up Chris Albert's drunk driving, because it has no bearing on this, and it has nothing to do with his truthfulness. But you should be able to bring up Paul O'Keefe's drunk driving. Colin wasn't in the house was a lie from Morrissey and the other witness that testified to that fact until it's proven he was. Then they admit he was there, but at a different timeline. Yeah. I have two thoughts. Either Bev thinks he'll be acquitted or it'll be dismissed. I don't know. I think Bev believes that she'll be convicted. I heard that too. It wasn't proven. The judge didn't feel he was impaired, so no breathalyzer test was made. So we only has his word for how drunk he was, and he could be lying, because you don't have to be truthful to girls you want to hook up with, even if it's online. Only infidelity, I know of it. Yeah, I had read that. What about grand jury statements changed during trial 1? Nothing wrong in that. They can do that every single day. They can change the entire statements from trial 1 to trial 2. if they want to. Because, and that's the thing that you guys have to remember. It's not perjury if you lie for the state. Who is the one who has to charge you with perjury? That'll be Special Prosecutor Brennan or ADA Lally. If you lie in a way that benefits their case, do you think they would ever hit you with perjury? Of course not. Come on now. As long as you lie for the right side, you won't get in trouble. Just gonna download the last ones. Commonwealth's motion in limine to prohibit referencing to any pending internal affairs investigation sustained findings unrelated to this case an unfounded allegation of misconduct. Who could this be about? Prohibit disclosure or reference to any internal affairs investigation pending against any law enforcement witness. The Commonwealth further moves in limine to prohibit disclosure or reference to any internal affairs investigation with sustained findings, as they bear no relevance nor do the findings relate to any bias exhibited by those against whom findings have been made. Internal affairs investigations are confidential, and disclosure of any investigations that are not resulted in a sustained finding of misconduct would serve no purpose other than to risk materially prejudicing the proceedings or confusing the jury. Moreover, the Commonwealth moved to prohibit reference to any civil lawsuit filed against CPD Sergeant Lang relating to an incident that occurred nearly 20 years ago. That's when he beat up a guy. In the federal lawsuit previously relied upon by the defendant, there was no adverse credibility determination against Sergeant Lang or any finding of liability. The case was dismissed by agreement of the parties. Until a finding of liability has been made, a pending civil lawsuit constitutes an unsubstantiated allegation of police misconduct that does not tend to negate the guilt of a defendant. Finding of civil liability made against prosecution team members in the performance of their official duties are subject to automatic disclosure and falls within the duty of inquiry. Pursuant to Graham v. District Attorney for Hampton District, if a police officer's credibility is critical issue at trial, the judge has the discretion, in the interest of justice, to admit evidence of specific instance of the officer's false statements in prior unrelated matters. Matter of a grand jury investigation. A judge, in deciding whether to allow a police officer witness in the interest of justice to be impeached with prior misconduct, may consider the aids of the prior misconduct, the strength of the evidence of the misconduct, and the simplicity of establishing it, and whether the prior misconduct is probative of how the officers conduct police investigations. Matter of the grand jury investigation. In instances where there have been no sustained findings of misconduct, the jury should not be permitted to consider any allegations of misconduct, whereas disciplinary actions is but one possible outcome. Exoneration and protection of the officer and the department from unwanted criticism is another. Worcester Tell and Gazette Corp v. Chief of Police of Worcester. In instances where sustained findings have been issued which do not reflect untruthfulness on behalf of the officer nor exhibit any bias against the defendant by the officer against whom sustained findings have been made, the conduct is equally inadmissible and lacks relevance. Further, the Commonwealth requests advance notice and production of any reciprocal discovery related to specific instance of prior misconduct or false statements that the defendant seeks to introduce and to use to impeach any law enforcement witnesses. So give us all of your impeachment so we can use it to prepare our witnesses. I just have to say 590, 595, 596, 597, 598. Yes. So Sergeant Lang and his little Canton kerfuffle shouldn't be allowed in this case. I'm gonna do as quick as I can bio break, and what do I have? You can enjoy some.
I'm Jimmy. How y'all doing?
You know Mauricio?
Yes.
When did you first meet Mauricio?
This is the summer.
Now in silence, asleep. Great beloved reason with so bright. Your tweets are missed day and night. Oh, grandma.
I needed that. Commonwealth's motion in limine to preclude the defendant from raising a third-party culprit defense. The court preclude the defendant from raising a third-party culprit defense. The defense position has chronically been fluid and unsubstantiated. The defense claims have been nebulous from its origin. Karen, just to be clear, you didn't do it. We know who did it, Steve. We know, and we know who spearheaded this cover-up. You all know. That's a YouTube link. After the first trial, the defense position began transforming. We are going to retool everything, and maybe some things will stay, some more, but we're going to shuffle a lot of things around. Also from a YouTube video. Most recently, in its Fox 25 sit-down, the defense responded to the question, in your opinion, there have been a few names that had surfaced in this third-party culpability theory. Who do you think? If John was beaten up and attacked in that house, who did it? Defense counsel uttered, we don't know. The defendant quickly echoed, we don't know. Counsel further, and it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John. But who it was specifically, others know and they are not talking. The evolving responses has vacillated from an undefined certain villain to not knowing who is responsible and have been the hallmark of the defense third-party culprit claims since its inception. The defense is not entitled to simply engage in scorched earth tactics, making baseless and incendiary claims about witnesses without any evidentiary foundation. Prior to the first trial, the court made rulings relative to the defense third-party culprit claims. The court ordered, based on the offer of proof on Friday, I am well within my rights pursuant to the case law to exclude the third-party culprit defense. I'm not going to do that now. I am going to give you a chance to develop it through relevant, competent, admissible evidence, but you cannot open on it. So that is my ruling on that. Another YouTube video. Despite the court's clear ruling, the defense launched into its third-party claims from the beginning of its opening statement. Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death, and that means that someone else did. Followed by, because the Alberts were involved and because they had close connections to the investigation in this case, Karen Reed was framed for a murder she did not commit. The evidence identifying or establishing a third-party culprit was never forthcoming throughout the trial and to this day continue to be non-existent. The Massachusetts Guide to Evidence 1105 provides that evidence that a third party committed the crimes charged against the defendant or had the motive, intent, or an opportunity to commit the crime is admissible provided that the evidence has substantial probative value. In making the determination, the court must make a preliminary finding that the evidence is relevant, is not too remote or speculative, and will not tend to prejudice or confuse the jury. If the evidence is otherwise inadmissible, the court must also find that there are substantial connecting links between the crime charged and the third party, and between the crime charged and another crime that could not have been committed by the defendant. After 3 years, the defendant has yet to provide any evidence as to whom they suggest is the third-party culprit responsible for the victim's death or any evidence of an alternative circumstances that would have caused the victim's death. The absence of an evidentiary basis to support a third-party culprit defense was clear before the start of the first trial. To accept the defendant's third-party culprit defense, the court would have to find the defendant demonstrated that acts of the other persons are so closely connected in point of time and method of operation as to cast doubt upon the identification of the defendant as the person who committed the crime. Commonwealth v. Conkey, quoting Commonwealth v. Hunter, the evidence must have rational tendency to prove the issues raised and cannot be too remote or speculative. Commonwealth v. Rule. Therefore, the defendant would have to provide evidence of substantial probative value that another individual had the motive. I know a guy, and again, this is just me. Someone had the motive. Well, intent. Look at the video from the bar where well is being held back by someone. An opportunity to commit not only red rum, and this is a shitty little thing. But who had the opportunity? Someone who might have been in close, what do you call, have been close to the place where they found John O'Keefe. But putting this in here, but vehicle manslaughter and leaving the scene of causing a death. No, that's because that's your fucking theory, which is a retarded theory because no one says John O'Keefe was hit by a car other than Trooper Paul, who never visited the crime scene, never saw the body, who didn't even know where the debris field fell. You just put this in here, even though no evidence has been provided that John O'Keefe was hit by a car. You can't even prove it's a vehicular manslaughter. And now you're using that as your crux to get the third-party culprit defense away. I know I shouldn't get angry. I should just laugh. Maybe because the responsible destroyed the devices so that it couldn't be analyzed. John O'Keefe went into the house and some of those in the house had opportunity and motive to do so. Maybe someone who had been trying to get in a relationship with John O'Keefe's girlfriend. Someone who can be seen in the bar video, and I really hope that the defense, and I know microdots have, I really hope we can see the pointing videos. That's not too far from removed in time, and it shows clear to me that someone had a motive because he was scorned by Karen Reed, and someone had the opportunity because he was at the address And the intent, the way he's standing, pointing. Yeah, MT, you make too much sense. To raise a third-party culprit defense to one charge that is so closely intertwined with the other charges would pose a real threat of prejudice by confusing the juror and diverting their attention to wholly collateral matters involving persons not on trial. You still haven't proven anything with a car. Nothing with a car. Excluding third-party culprit evidence where testimony was consistent between proffered culprit and other witnesses, including police and EMTs who arrived on scene, and defendant's argument that culprit could have fabricated a story to implicate defendant, strained credulity, and was entirely speculative. The defendant's right to present a third-party culprit defense is not absolute, and the admission of feeble third-party culprit evidence poses a risk. It's not a feeble third-party culprit. If you look at everything we were presented with by you, Hank Brennan, special prosecutor, because you are the head of the Commonwealth now. We know Higgins was hounding for Karen Reed that night. We know that the McAlberts weren't the best friends, Mr. Nepperknacker or whatever that name is. We know no injuries consistent with being hit by a vehicle happened. You should be the one telling the court how you believe you can prove your shitty theory, because there's no evidence consistent with an automotive vehicle hitting John O'Keefe, because there's no injuries below his neck. Well, actually there's that red mark on his knee. Have you ever seen anyone being hit by 6,000 pounds going 24 miles per hour? You don't get bruises. You get broken bones. Could also be, or someone that he had yelled at. But this is why I hate this case, because they don't give 2 cents about John O'Keefe. They are just lying through their teeth. The defendant's right to present a third-party culprit defense is not absolute, and the admission of feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth. Jokes. Because it's inevitably divide jurors' attention away from the defendant on trial and into the third party, and essentially it requires the Commonwealth to prove beyond a reasonable doubt that the third party culprit did not commit the crime. No, just prove beyond a reasonable doubt that Karen Reed did it. You have a rock solid case. It's not a problem for you, is it? Asshole. Commonwealth v. Silva Santiago, internal citation, abrogated on different grounds by Commonwealth v. Moore, Commonwealth v. Shakespeare, Commonwealth v. Acevedo. The defendant's ability to mount a third-party culprit defense is not without limits. Additionally, hearsay offered for the truth of the matter asserted that a third party is the true culprit and not within a hearsay exception may be admitted only if in the judge's discretion the evidence is relevant, will not tend to prejudice or confuse the jury, and there are other substantial connecting links to the crime. Trial judge correctly excluded third-party culprit evidence involving 4 identified individuals, including evidence that the victim was nervous around individual who had criminal record, and evidence that one was initially a suspect in police investigation, as evidence was speculative and remote. Acevedo. Defendants proffer that victim was shot by an unnamed rival drug dealer was nothing more than rank speculation. Commonwealth v. Martinez. Evidence individual was banging on victim's apartment door. I thought banging his wife. The day she was killed, at most suggested opportunity to commit murder. An attempt to attribute that to motive or intent to kill would be impermissible speculative. Commonwealth v. Smith. Testimony of witness that In days prior to murder, victim had expressed fear about being harmed as a result of problems with an unknown woman and stuff in his past, was of minimal probative value and not admissible. Commonwealth v. O'Brien. Evidence that third party appeared at crime scene around the time of murder did not constitute substantial link between third party and murder. This court has the discretion to rule in advance of trial whether the defendant has made an adequate showing of potential culprits were connected to the crime. Commonwealth v. Buckman. The defendant must provide advanced warning to the court before offering third-party evidence or argument in trial. O'Brien. Judge determination of relevancy will not be set aside absent an abuse of discretion. The defendant has yet to make a proffer of substantial probative value that any other individual is culpable for her crimes. The arguments previously set forth by defendant in pretrial motions containing only vague inferences, rank speculation, and scant details of who, if anyone, had the motive, intent, and opportunity. Well, you put one on my list when you ask questions. A third-party culprit is simply a defense tactic to unjustly prejudice the Commonwealth and confuse the jury. See Rosa. The trial tactic is, like any other, limited by the fundamental principles that evidence must be relevant. If the defense offer its own theory of the case beyond merely putting the government to its proof, its evidence must have a rational tendency to prove the issue the defense raises, and the evidence cannot be too remote or speculative. It's not. For the foregoing reasons, the defendant should be precluded from alleging that any other individual is culpable for the victim's death, as there is no relevant and substantially probative evidence to justify the admission of such a speculative claim. Furthermore, despite this court's previous order denying the defendant's request to raise a third-party culprit defense during the defense opening statement at the first trial, Yannetti was permitted to declare 3 separate times that Karen Reed was framed. Should the court preclude the defendant from raising a third-party culprit defense counsel should be ordered to conform their arguments to the orders of this court. You have such a weak case that you want to put a gag order on the defense. Jesus Christ. For an energy drink, loving the stream. I am lucky that we are 1, 2, 3, 4, 5 left, because Daddy feels a little parched and a little hurt. I'm showing this again behind the screen. Thank you, Unbalanced. Little did Karen know that that fateful night she would become the face of shining light of corruption and unite the world. Free Karen Reed. Luckily, it was Karen they tried to frame, because she had the balls to go against them. Distraction, where do we know that word from? Yeah. At this point, you have to laugh, or yeah. So you think Brennan skipped the days innocent until proven guilty and reasonable doubt were thought in law school? I think so, yes. Of course, their testimony was consistent. They had plenty of time to coordinate with each other, and they weren't sequestered during witness testimony like they should have been. And they were prepped by Lally, even during their testimony, during lunch for some of them, and as this entire role of the victim advocate, who did some go-between, allegedly. I am parched, and I don't have any more. Well, yeah. Did I miss Pimpernella? Hey, Pimpernella. Leave site. 590. Commonwealth's motion for attorney conducted an individual voir dire of potential juror and proposed jury questionnaire. Totally cromulent. Happens every time. It's just to test, so they have it when they are doing the voir dire of the jury. Defendant's motion in limine to allow counsel to state grounds for objections to promote judicial economy and efficiency and to adequately preserve issues. Oh yes, this should have been allowed all the times. Karen Reeve moves to allow both parties to briefly and concisely state grounds for their objection in open court during the retrial in this matter, in the interest of promoting judicial economy, the efficient administration of justice, and the preservation of issues. Undersigned counsel would like to note that this is not a request for lengthy speaking objection. Any issues that could be perceived as having an ability to coax a witness while on the stand or potentially bias the jurors with extraneous information will still be dealt with at sidebar. Counsel is merely requesting the ability to state grounds for the objection by way of example rather than simply stating objection. Counsel would state objection, hearsay. Objection calls for speculation, which they should be allowed to do. As grounds for this motion, Ms. Reed states the court's general order that counsel not state grounds for the respective objections before the jury led to extensive discussions at sidebar, which lengthened an already extensive juror trial. Ms. Reed further states that the inability of defense counsel to state grounds for objection could lead to their inability to preserve issues for any necessary appeal. Stating the basis for an objection in a word or two will not cause either side any prejudice. While Ms. Mead acknowledged that generally consideration of judicial economy must yield to the defendant's right to a fair trial, see Commonwealth v. Sylvester. In this instant, it is the defendant making this request. Massachusetts courts and the rules of criminal procedure has outlined several scenarios that demonstrate the general promotion of an interest in judicial economy and efficiency. For example, the Supreme Judicial Court has noted that joinder under Massachusetts Rule P, it's been a long day, may promote the economic adjudication of criminal offenses. See Cum Hoppin. Additionally, the Supreme Judicial Court has condoned the practice of taking motions for mistrial made during closing arguments under advisement until after the return of a jury verdict to promote judicial economy and efficiency and to preserve valuable judicial resources by obviating the need for retrial should the jury return a verdict of acquittal. See Cum v. Brannigan. Finally, judicial economy was explicitly cited as a consideration by SJC in eliminating the so-called power of resurrection in criminal case, noting, there are many rationales for the raise or waive rule. That it is a necessary corollary. Jesus Christ. Corollary of our adversary system. I don't know what that word is. Adversary system in which issues are framed by the litigants and presented to a court, that fairness to all parties requires a litigant to advance his contentions at a time where there is an opportunity to respond to them factually. If his opponent chooses to, that the rule promotes efficient trial proceedings, that reversing for error not preserved permits the losing side to second-guess its tactical decisions after they do not produce the desired results, and that there is something unseemly about telling a lower court it was wrong when it never was presented with an opportunity to be right. The principal rationale, however, is judicial economy. There are two components in judicial economy. If the losing side can obtain an appellant reversal because of error not objected to, the parties and public are put to the expense of a retrial that could have been avoided had an objection been made. And two, if an issue had been raised in the trial court, it could have been resolved there, and the parties and public would be spared the expense of an appeal. Commonwealth v. Bly, quoting Commonwealth v. Alphas. Related to the now defunct power of resurrection doctrine, the failure of counsel to state grounds has, in at least one instance discovered by the undersigned counsel, led to an appellant court holding that counsel had failed to preserve an issue. In an unpublished decision in Cum v. Cabral-Varela, the appeals court of Massachusetts outlined a scenario that could easily occur in this matter, absent the allowance of this motion in limine. The key passage of Cabral-Varela opinions read as follows. The most hotly contested issue at trial was the identity of the shooter. The Commonwealth sought to establish the defendant's identity in part by introducing a security video of the shooting that showed the shooter wearing a white t-shirt and eliciting evidence that was what the defendant habitually wore. This evidence consisted of testimony to that effect from a precipitant witness, Erica Moody, a police officer, Kevin Swan, who was familiar with the defendant, and a police detective, Kevin Dugan, who had participated in the investigation and had viewed the defendant's social media pages. Dugan also authenticated 2 social media photographs of the defendant wearing white t-shirts. The defendant argues on appeal that this was inadmissible habit evidence. The parties disputed the standard of review with respect to the habit testimony. The defendant argues that the issue was preserved and that the standard of review is for prejudicial error. The Commonwealth argues that it was not, and that the standard of review is for a substantial risk of miscarriage of justice. We agree with the Commonwealth. The prosecutor twice asked Swan whether the defendant typically wore any particular type of clothing. The defense counsel objected to the first question without stating his grounds, and the judge stated sustained as to foundation. The prosecutor immediately laid a foundation and asked the question a second time. Defense counsel again objected without stating his ground, and the judge overruled the objection. In these circumstances, it is clear that the overruled objection was based on foundation grounds, which is sufficient to preserve an objection on habit grounds. Commonwealth v. Fowler. While defense counsel objected at sidebar shortly before Dugan's testimony, the objection was only to the introduction of these photographs, not Dugan's testimony, and was on cumulative grounds, which is also insufficient to preserve the issue for appeal. There was no objection at all to Moody's testimony. Commonwealth v. Cabral. Put simply, defense counsel's failure to state grounds for his objection led to appeals court to infer the grounds for his objection, and having done so, to determine that the defendant was entitled to less deferential standard of review to which he would otherwise have been entitled had the correct issue been preserved. Although the court went on to say, even if the court had applied the more deferential prejudicial error standard, which it did not, the court would still have determined that the error did not influence the jury and had but very slight effect. Citing Commonwealth v. Fleabottle. Quoting Commonwealth v. Peruzzi. More important than the specific fact in the case, however, is the fact that the appeals court agreed with Commonwealth that because defense counsel had failed to adequately preserve the issue because he failed to state the correct grounds for objection, the standard of review on an appeal would be less favorable to the defendant, substantial miscarriage of justice. Since the abilities to state the grounds of objection will both further the interest of the court and the public in judicial economy and the efficiency interest of justice, will avoid the possibility of failure by counsel to have the ability to adequately preserve any possible issue for any necessary appeal, and 3, would cause prejudice to neither party. Ms. Reed respectfully request that counsel be allowed to state the grounds for objection during this retrial on this matter. For the above reasons, she requested. It would be fun when Bev have to say, Lally, do you want to object on the grounds of speculation? Lally, do you want to object on hearsay? Affidavit of counsel in support of defendant's motion limited to allow counsel to state grounds for objection. It's just the same again. Defense motion to impound the defense motion limited to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. Now comes defendant Karen Reed and respectfully move this honorable court for an order impounding defendant motion to prohibit the Norfolk District Attorney of Massachusetts from having juror contact because the exhibits supporting the motion as well as discussion of these motions are subject to this court's order of impoundment. Again, we don't know what it is. Specifically, the transcript of the June 25 sidebar conference, Exhibit A, and the text message exchange, which include Lieutenant Fanning and Trooper Proctor. Exhibit B must be filed under an order of impoundment. Now I want to know what's in it. The last one. Affidavit of counsel in support of defendant's motion to impound the defense motion in limine to prohibit the Norfolk District Attorney and Massachusetts Police from during contract. That's the same we just read. Na 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 na. I am so done now. Oh, my voice is so busted. I can talk no more. Hui! Thank you for all of you 155 who's still hanging on, because this was 3 hours of reading. I can begin to feel like I kind of, when it feels like you're getting a, what do you call it? We call it neck infection, or throat infection. I can't remember what's called in English. If I do my math correct, there were 38 different motions. Some of them we skipped through, some of them we read. The overall picture to me after reading this is the defense want openness. They want all of the evidence presented, and the state wants none of the evidence presented. I think that's where I am after 3 hours of reading this, is they don't want anything out there from the state. Laryngitis. Could be. It's the one where you have like an inflammation in your throat. But to me, it's the same pattern we've seen the entire time. The defense comes up with motion after motion after motion, which to me paints a picture that they should probably be heard. And Bev should probably rule favorable to them, at least in some of them. Of course, not in all of them. And all the Commonwealth is doing is just saying, nah, we don't care. We don't want anyone to know anything. Just go to prison, stay in prison, and accept that we deemed you guilty. And that's not justice. She should be allowed a fair trial. She should be allowed to call her witnesses. She should be allowed to put on a third-party culprit defense, not hampered by all of these stupid motions. She should be allowed to call Meatball Morrissey, because he made himself a part of this case when he did his hostage video. All Hanky wants is to exclude all exculpatory evidence, her lawyers, and sharing info. In fact, let's just skip the trial part. Yeah, he should just make his final motion, should just be, baby, find her guilty, skip the trial. I'll allow it. But most of all, I'm just looking forward to, I don't think we can do it in 8 weeks.
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break, and both sides take a pregnant pause and think about the jury.
I'm Jimmy. How y'all doing?
You know what we do?
Yes.
When did you first meet Maurice?
This is the summer of 14.
And where
Oh my gosh, you guys! There's a class called Basic Grifting. Should we all learn how to be grifters together?
Everyone, thank you so much for stopping by. Thank you so much for all the super chats, all the likes, hopefully a few subscriptions. Tomorrow, I will be joining Tom CPU at 9 Eastern, 9 a.m. Eastern. I don't know where he's going to take me, but hopefully he'll take me by the hand and lead me somewhere special, because I need it after today. Well, you have to get home earlier. I hope the rest of you will have a wonderful day. It's 10:15 here. I'm gonna make myself a slice of knäckebröd with some cheese on it, and sit down. Maybe have something to calm my throat. I'm thinking I'm gonna make myself a hot chocolate tonight. I deserved it, and all of you deserve to have a wonderful day. Please join me tomorrow over at Tom CPU, where I don't know where we're going, but we normally have fun when we go there. So just remember, every time you think it's bad, Brennan Special Pro Sector will make it worse.
I'm not crying, you're crying.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
correct.
Objection, Your Honor.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love. Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there.
Everybody has.